Lord, may I have your lordship's kind leave to mention a section 34 matter, my lord. It's ready for hearing. My lord, Mr. Shaha is online. It is, we are for the respondent, my lord. It's not my section 34. My lord, award of 2018. 7 years have passed. They've secured the money. Hence, the award is stayed, my lord. The execution is not proceeding, my lord.
Take it in the
My
normal
lord,
course.
it's in the list.
We'll see that. No upgradation. Yes, yes.
Was busy and lodged asked us to mention. It's a matter, my lord, arising out of an interim order passed by an arbitral tribunal. So it's a section 37 appeal I have filed. The urgency is this, that there's a contempt proceeding pending against me, my lord, before the arbitral tribunal itself. And that is coming up for final hearing next week on Tuesday. So subject to your lordship's convenience, if it could be taken up tomorrow or even on Tuesday, I'd be most grateful. It's a new motion. Matter was heard by Justice Kapoor. It was part heard before him. We were trying to settle the matter. Ultimately, the settlement talks failed. So he's released the matter, and now the matter is before your lordship.
Your lordship, in this matter, I'm not.
Give the slip, we'll see that. Give the slip, we'll see.
I'm grateful.
My lord, may I be permitted to mention a matter for settlement, my lord? It's item 106. May it be listed on Friday, my lord, under the heading to be mentioned? The other side is here. List on Friday.
Yes.
May I permit to mention, this is contempt application, my lord. This is passed by your lordship and dated 23 March 2020.
Take it. Appellate side, right?
Appellate side.
May I permit to mention one matter, your lordship? This is that execution application. I'm for the MSME, your lordship would remember this matter. There's a restoration application pending with respect to section 34 application filed by them. The matter is coming on the 9th, your lordship. If those matters can be tagged along, your lordship. They have also filed a review application.
We'll see that on that day. This is regarding that payment which has to be
Yes. Very good. Wait, my lordship.
May I have your lordship?
If your lordship, if that matter could be at the top, your lordship.
There's no question about the top.
May I have your lordship kindly leave to mention a matter wherein your lordship, by the order dated 18 November, had appointed Justice Ashok Kumar Ganguly as an arbitrator. He has recused himself by the email dated 3rd January, stating that he is an arbitrator wherein a party,
So move an appropriate application, madam.
Okay. I mentioned a matter to your lordship. I'm mentioning this of a notice, lordship. I'm praying for inclusion of a matter, lordship.
Inclusion of what?
A 34 application. The appeal has been already been disposed of.
Appeal?
Appeal moved by the petitioner, lordship. I'm appealing for the defendant.
So 34 has been disposed of.
No, appeal has been disposed of. The 34 application, I'm praying for the inclusion.
Award has been passed.
Lordship.
It's
It is only for
it's a
dismissal.
new motion.
Lordship.
It's a new motion.
No, new motion. 34 application, lordship.
So upgradation, what do you want?
Not upgradation. I'm for inclusion.
Inclusion.
Inclusion in the list, lordship.
Not in the list.
Grateful, lordship.
Call out the list.
I'm appealing for the award holder, lordship. The matter has been already been settled between the parties, and I'm appealing for withdrawal.
Take down. The petitioner seeks to withdraw the present petition in view of the settlement arrived at between the parties. Any instruction?
No, lordship.
The petition stands dismissed as withdrawn.
Grateful.
In this matter, I am appealing on behalf of the petitioner. Here's my affidavit of service. As your lordship last order, I have rightly served the party.
Yes.
Your lordship, this is in a third time seeking extension for arbitration mandate. Page 25, 8 December 2021, this Honorable Court appointed the arbitrator to adjudicate the dispute between the parties. The first extension, your lordship.
When was the appointment done?
8th December 2021. The first extension was mutually agreed by the consent of the parties for 6 months. That is happened on 18th August 2024, 23, your lordship. And thereafter, your lordship, the second extension application was filed before this honorable court, which is at page 45. By an order dated 21st November 2024, the extension was granted for a period of 1 year. And thereafter, your lordship, the seeking the third extension, the present proceedings of the stage, your lordship, the evidence of the complainant is claimant is completed.
Why is it going so slow?
Your lordship, the initially the witness represented by the claimant, that is the expert witness, during the cross examination, the claimant finds that the witness is not a compatible witness because he's not physically fit, he's suffering from mental illness. So first witness has been expunged, thereafter the second expert has been appointed, and thereafter the evidence has been going on, your lordship. So for that, the time has been consumed a lot. And your lordship,
Who's the arbitrator?
your lordship, arbitrator, your lordship, the arbitrator, your lordship, at the retired district judge, your lordship.
Too much time is being taken.
Your lordship, page 25, the arbitrator name is there, your lordship. At page 26, your lordship, at the bottom, the name of the arbitrator is there. He is a retired district judge, your lordship. That the respondents is not cooperative the proceedings, your lordship. The respondent on and in every occasion short time.
You see page 46.
Yes, your lordship. That is a that is second extension, your lordship.
One last opportunity is
One
granted
last
to the-
opportunity given of that's last and final is it is completed, because kindly, your lordship, kindly come to the minutes, your lordship, kindly come to the minutes. Hmm. Minutes at page 63, your lordship. At page 63, 27 sitting, the conduct of the respondent is herein below. And thereafter, he produced the medical documents before in compliance of these 27 minutes. That is the forged one. Hmm.
Take down. The petitioner has preferred the present application under section. Petitioner has preferred the present application under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of the arbitral tribunal, extension of the mandate of the arbitral tribunal for completing the proceedings and publication of the award. Learned counsel petitioner submits that this court-wide order dated 8/12/2021 appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. Thereafter, with the consent of the parties, the mandate of the tribunal was extended by 6 months. Full stop. Thereafter, wide order dated 21/11/2024, this court extended the mandate of the tribunal by 1 year. It is submitted by the learned counsel for the petitioner that the mandate has expired on 9/12/2025. He further points out that the matter is at the stage of claimant's evidence. Full stop. It is learned counsel for the petitioner further states that the tribunal has conducted more than 31 hearings and the matter is at the stage of claimant's evidence. Full stop. Upon consideration of materials on record, this court is satisfied that there is no delay attributable to the learned sole arbitrator in conducting the proceedings. Full stop. Having regard to the advanced stage of the proceeding and in the interest of justice, the mandate of the learned sole arbitrator is extended further for a period of
1 year I have prayed.
no 1 year.
Your Lordship, as I leave it to your Lordship. I leave it to your Lordship.
1 year arbitration, you will for a period of 8 months from today to conclude the proceedings and publish the award. Full stop. The learned sole arbitrator is requested to make all reasonable endeavors to conclude the proceedings and publish the award within the extended time period. With the aforesaid observation, the present petition stands disposed of. Affidavit of service. ऊपर ही लिख देना. Affidavit of service is taken on record. None appears for the respondent.
Your Lordship, extensions were granted for 8 months.
8 months.
Much obliged. Much obliged.
Three, I appear for the petitioner, my lord, my section 9.
I'm appearing for the defendant, my lord. My lord, we have filed our opposition.
Pleadings are
May the-
complete, my lord.
my lord,
May
there
I
was a
proceed?
direction to also to file, my lord, the bank statements and the account details. My lord, though we had supplied, my lord, the last location, the affidavit was not ready, my lord. We are filing that affidavit in this regard. Copy. Lord, I'm handing a copy. my lord.
File your reply to this or
My lord, it's just a bank statement. What reply do I need to file?
to you? I'm just
Yes,
asking.
yes, yes.
File your reply.
I'm not going to file a reply. my lord. Either way, it has successfully lingered. My lord, my application under section 9. Kindly,
We filed a 11.
I have not yet
appointment?
filed. If my learned friend gives a consent, we can get the appointment here and now.
No, my lord, we say that this application is not itself maintainable.
Application is not.
It's not itself maintainable, considering the facts of the case.
In that case, my lord, may I
No, I'm
proceed?
not talking about the application. I'm talking about appointment of the arbitrator.
My lord, for that I have to take instructions. As of now, my lord, what I have taken, my lord, he is not ready for the arbitration because we say we also want to have, my lord, we also have due from them.
So that
Whatever
is
it
why
is, that has to be
arbitration,
disputed.
more
My
reason
lord,
to go to
let the matter be sent, my lord, for amicable settlement for wars. If it is goes for mediation, if it can be settled in mediation, that
Lord,
is
if I
between the
settle in, Lord, if I submit in one line, my lord, I'm to get 10 lakhs from him. If he is ready and willing to pay, I shall close the matter here and now. But if he's not, then Lord, I have to proceed.
may I submit, my lord? May the matter be sent back to mediation, my lord?
Why mediation? What purpose? No
Lord,
purpose will be
it will
served.
only take 2 more dates.
They are in
Maximum to
control of the bank account, in business, everything they are in
Is there, my
control.
lord?
What mediation?
You don't want a mediation. Mediation can only be with the consent of the parties.
Lord, mediation, Lord, with deepest of respect, Lord, only lingers the matter. Nothing fruitful happens in mediation.
This is, my lord,
You want the dispute to be adjudicated, let us go into arbitration.
Lord, I want the matter to be settled, but I say I have 90 lakhs pending from them. Why would I am they were
I
the
can refer the
shareholders.
matter for mediation only if both the parties agree. He is not agreeing for it. If you want arbitrator to be appointed, we can appoint an arbitrator, send you back to
Yes.
the
My
arbitrator.
lord, here's this out, my lord. Then here's this application out. If after hearing this out, my lord, we say we are not ready for arbitration.
Not ready for
Not
arbitration.
ready for arbitration.
Despite
How will
there
you
is an
recover your
arbitration
money?
clause.
My lord.
How will you recover your money?
My lord, we will see, but as of instructions, my lord, I say that we are not ready for. I have taken instructions from the client. They say they are not ready for arbitration.
What my lord is asking, you answer the question.
Yes, I get that. But if my clients are not ready, then how would I come and submit that they are ready or not?
Very well, my lord. Then in that
Yes.
case,
Yes, sir.
kindly takes my application under section 9, my lord.
Yes.
The dispute is very, my lord, it arises out of a joint venture agreement dated 13th of May 2025. Very limited, my lord, very short facts. My lord, me and my brother, the petitioners, my lord, are the proposed investors who had invested 10 lakh, my lord, who were to become the shareholders of this particular company who is engaged in logistics. Now, my lord, upon signing of this agreement and upon making payment, I was to get the exclusive bank account details. Banking operations rights. That I'll just show, my lord. Kindly takes page 28. Page 28, my lord, under Article 7.1, I am to get, my lord, the sole signing authority. The petitioners. The third and fourth party are the petitioners. The second sentence of that particular article. Now, my lord, that obviously didn't happen. There are series of letters, but only two clauses which are relevant for this particular to my lord today is, my lord, one is at page 35. 35, my lord. Paragraph C says that I will provide 1 lakh as capital investment. That I have done. Page 35, paragraph C. Page 30, my lord, under Article 13, any further fund over and above 1 lakh will be treated as loan by me. My lord, admittedly, I have paid 10 lakhs. My learned friend have admitted in their affidavit in opposition that I have paid 10 lakhs. So I need not show that. Now, my lord, the subsequent part with what happens, my lord, after signing of this agreement, there have been repeated correspondence asking them to comply with the provisions of the agreement, which is giving me the banking access and not the business details, which is inputs and outputs, whatever is there. Two letters I'll just show. Kindly sees immediately after, my lord, this agreement, which is May 13, 2025, my lord, after series of approaches at page 48, I write them that, my lord, there have been serious discrepancies in the company, and my lord, we don't want to continue with the collaboration. We just say that you please return my 10 lakhs. I'm ready to walk out of this agreement. My lord, so is, my lord, page number 49, and thereafter page 50 is the, my lord, list of defaults which has been committed by them. One of which is most important is that they have taken away my access from the official email ID and from the Tally ERP system, from where I would get the details of, my lord, the sums which are coming in and which are going out. My lord, this dispute carried on, my lord, and my lord, subsequently, when, my lord, we saw that they are taking out money from the business, we requested the bank to put debit freeze. Now, my lord, very surprisingly, debit freeze was put into the bank account, and kindly takes that particular report which my learned friend has filed today. Your Lordship will find at page 23
Of the reply?
of the report, not of the reply, of the report, which, my lord, today which they have filed just now.
That we filed today.
Just now which they have filed. Page 23, your Lordship will find on 28th of August, debit freeze was put into effect. My lord, on 29th of August, my lord, one party gave a payment of 4,86,000. Your Lordship has your Lordship found that? At page 23,
Yes.
first entry.
Yes.
28th, my lord, debit freeze was put. 29th, one of the clients of this company, my lord, gave a payment of 4,86,000. My learned friend's client went to the bank, approached the bank, and, my lord, got the debit freeze revoked. And, my lord, at page 22, your Lordship will find, then and that day, on that day, my lord, he withdraws 2 lakhs rupees in his own name, and, my lord, 286 in my lord, another account of that company, in which, my lord, I do not have even the access details. This much, my lord, I had the details. I approached the bank, but, my lord, this is the approach. Then, my lord, when I give them notice, my lord, your Lordship will kindly sees in my section 9, my lord, they refuse to take notice. That's at page 66. Very limited prayer, my lord, today I am seeking, my lord. And, my lord, one more thing, one important fact. In the affidavit in opposition that they have filed,
Dikhana.
in paragraph 8 and 9, my lord, they admit the investment that I have made. And, my lord, they do not deal with paragraphs. They only deal with paragraph till paragraph 13 of my said petition. Other than that, they don't deal with. So I presume that they admit the statements made in paragraph 14 onwards of the said petition. At page 9, your lordship will kindly see paragraph 18. They only deal with paragraph 10 to 13 and rest, my lord, they leave as it is. My lord, admittedly, my lord, that I have paid 10 lakhs rupees. They are in receipt of that 10 lakhs rupees. And my lord, there is no such promise under the agreement that I am to give anything more or something like that. I have given 10 lakhs rupees. I have given 1 lakh rupees. They are in custody of that money. They have successfully taken away that money. Today, I am just praying, my lord, that my lord, let that money be deposited before the registrar. We will fight before the arbitration. If my lord he wins, he will be successfully, he will be, my lord, fully compensated by the money which is deposited with the registrar along with
But
the
why you
interest.
have not invoked the arbitration?
My lord, I want to invoke the, my lord, the moment
What
I
is
filed
it?
the Section 9 petition, I thought, my lord, that, my lord, we'll get the matter heard in a month or so, but, my lord, the matter didn't
You have
happen.
moved to section 11.
My lord, I'm saying, my lord, that if he is giving consent, let us proceed with the
Forget
appointment.
about his
But,
consent.
my lord,
Why
today,
did you move in section 11?
my lord,
Nobody
I
was
shall,
stopping you.
my lord, I shall move my Section 11, my lord. I
You
was,
just want relief
no,
in
no, no,
section
my lord,
9
I
and sit
was,
over it.
my lord, I will
What is
definitely,
the
I'll have to
purpose?
proceed before the arbitration.
Then why don't you do
But,
it?
my lord, today, my lord, it cannot be the matter, my lord, that they'll be in custody, they'll take everything away, and
Sit
then, my lord,
over
I'll
these
have to run
cases,
from pillar to
filing
post.
section 9, doing nothing else.
No, 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 my lord, that is not the, that is not the
Exactly what
idea.
is being
My
done.
lord, we will file our Section 11, my lord, within a, my lord, within the next week only, my lord. By next week, we'll file my Section 11. But, my lord, I am saying, my lord, that, my lord, this protection should be given. Today, my lord, I am out of business. Today, I am out of funds. It cannot be the situation that they'll be in custody of the money and the business and they'll take everything away. And then, Lord, they'll come and they'll say that I'm not agreeable to arbitration. There being an arbitration clause. That also cannot be the fact, Lord. I'm just not praying for this much indulgence. That not let that money be deposited before the registrar. They should not be in custody of the money and in the business, and they'll make me run from pillar to post. Even till today, Milord, I do not have any access. What is happening? What liabilities am I being saddled with because I've been made a shareholder in this company? I don't know, Milord, what subsequent thing will happen. I'm just saying, Milord, that Milord, let this money be deposited with the registrar. I'm not asking it to be given to myself. This is an unimpeachable money claim, Milord. There's nothing that he will, Milord, there's no probable defense that he can have. I'm just saying, Milord, that Milord, this money be deposited with the registrar. Whoever wins, Milord, will get the money along with the interest. So there is no inconvenience which will happen to either of the parties. Respondent number 2, Milord, who is instrumental in doing everything, Milord, he is withdrawing money in his own name. Your Lordship may kindly sees the bank statements that he has annexed. Every second statement under withdrawal, Milord, will reflect his name. That also cannot be, Milord, the purport of the agreement, Milord. When, Milord, under the agreement, I am to have the signing authority, I am to have exclusive authority over the banking informations and, Milord, the business. He has just simply taken the money and I
Not
have
exclusive at all.
Yes, Milord.
Clause which you have read out is not exclusive. It's a joint
May I
account
read
which
this,
has to
Milord?
be operated.
Milord, may I read it again? Kindly come, Milord, to page 28. Milord, two bank accounts will, under Article 7.1, two bank accounts will be created, one for receiving payments from all clients and loan and investment from third and fourth party. I am the third and fourth party. Your Lordship will find at page 24. Then, Milord, it says the third and fourth party will solely be the signing authority in the primary bank account. And the signing authority of the secondary bank account will be any three directors mutually decided. So the first bank account where, Milord, payments are to be received from the clients, Milord, the petitioners have to be, are the sole signing authority. I've requested them that you please make me the signing authority. They don't make me. Today, Milord, I'm just saying, Milord, this very limited prayer that, Milord, let that money be deposited with the registrar. It will be invested in an interest-bearing account, Milord. Whoever wins in the arbitration will get that money. Admittedly, he is in receipt of that 10 lakhs. He has admitted in his affidavit in opposition. I don't need to show anything else. And moreover, the transactions are through bank. It's not through cash or something like that. Meager amount has been invested in cash, 1 lakh or something. But Milord, that also I don't have to prove because he has admitted in his affidavit in opposition, paragraph 8. I'm just, Milord, praying for this limited prayer, Milord, today. And Milord, your Lordship may, if he's ready and willing to give consent, we can have an arbitrator appointed here. Otherwise, I'll proceed with the filing of section 11.
You could have done that, irrespective of his consent. Yes. That's it.
Yes, my lord, that's it.
Malad kindly looks into the joint venture agreement, page 23 of the section 9 application. इनका signature नहीं है। Now, my lord, the agreement, Malad kindly take to page 24. The agreement has been entered by on behalf of the defendants, my lord, Pradeep Jha, number 1, page 24, my lord.
Yes.
Sandeep Jha, Sandeep Sinha, Dipankar Shaw, Ajay Shaw. Now, my lord, this agreement, though there is an arbitration clause, my lord, under which my lord, my learned friend has invoked the section 9, does not bear, my lord, the signature of the MD of the company who has been incorporated as respondent number 4 in this section 9 application. This is the agreement they are relying upon, my lord.
Yes.
My lord, the bottom portion of the agreement consists of the signatures, my lord, of the parties.
Right.
None of the pages that has been annexed, my lord, consists, my lord, the signature of the respondent number 4, that is the MD of the company.
He's the director of the company.
My lord, the rest of the 3 people that had been incorporated, my lord, the Pradeep Jha, Sandeep Sinha, and Leelakant Jha.
Yes. So what are you saying? You never entered into a joint venture agreement?
Well, they were, but
Are you
my lord,
disputing the joint?
these parties do not represent Barsana Supply Network Private Limited.
Barsana Network is the
That is the main defender. That is the company, my lord.
Yes.
My lord, they have never, my lord, put the, my lord, it was, my lord, I must not say like this there, but they were the respondent number 4 was in notice of that they were
Sir,
to
what
enter.
are you trying to say? That Barsana never entered into a joint venture agreement with these 4 people?
My lord, we say that Pradeep Jha, my lord, and my lord, the Sandeep Sinha, my lord, were never given power to enter into an agreement with the petitioners.
Forget about them. You have entered into the agreement. You are for Barsana, right?
Yes, my lord.
So you have entered into this agreement. So either you are denying this agreement, joint venture agreement.
I say, my lord, this agreement does not constitute the signatures of the MD of the company. That is what I am
So
saying.
that's what I'm saying. That means you're denying the agreement, that you have never entered into the agreement.
No, I cannot deny because there were signatures of Mr. Pradeep Jha and Malazare, but the MD of the company is, but though he is incorporated as one of the defendants, one of the respondents.
All right. As a director.
As a director. Second of all, my lord, the admission that my learned friend is saying, my lord, that has been made because of labors and other supply payments, not to us directly. But there was a understanding.
Please see page 38.
My lord. Yes, my lord. Yes, my lord, I've seen.
Respondent number 4 has signed. Leelakant Jha.
No, respondent number 4 was my lord.
Who's respondent number 4, sir?
इनका sign है क्या?
What arguments are you?
No, I say upon instruction, this is not his signature, my lord.
Sorry?
This is not his signature.
Oh, you're disputing the signature.
This is not his signature.
File a criminal complaint.
Well, I've taken that point in my opposition even.
All right, very good.
That is the main dispute, my lord.
All right. Very good. What else?
My lord, another thing is that, my lord, there was an understanding that they would take over the company, including their shares, and they would hand over money to it. In respect to that, an advance payment was made not to us, but to on respect of other heads. Now, after that, my lord, they wanted to take over the company without paying us the money. That was the main dispute.
No.
And in regard to that, we said pay us the rest of the amount so we could hand over the company. Now they are neither they paying us the amount nor they are handing over the amount. That's why we are not handing over the company. The dispute remains to on that respect only. That is why, my lord, I was praying, my lord, maybe sends to mediation, my lord. Let my friends sit with my clients, my lord. Means he has a claim of rupees 10 lakhs only, my lord. If that can be sorted, my lord, we can pay it off.
All right, take down.
Lord, just two things I like to
Yeah.
know, my lord. The payment which he's saying that I made to labor and all is not correct, my lord. Page 40 onwards, I've annexed the payment proofs that has been directly sent to Barsana. That is the respondent number 1 of my
Yes.
petition.
जो बोल रहे हो वो डॉक्यूमेंट जो है वो एक नहीं है जो बोल रहे हो कहाँ पे लिखा है? बोलो इसीलिए तो हम बोले थे पूरा अकाउंट चेंज हो जब से हम बोल रहे थे कब से हम बोल रहे थे
It on the petitioner had entered into a joint venture agreement with the respondents on 13th May 2025. It is the case of the petitioner that they had invested a sum of rupees 10 lakhs into the joint venture agreement for running of the business. Full stop.
देखिए तो है 1 लाख का बस 1 लाख का पैसे 9 लाख तो उसमें
The petitioner states that
देखो कह देता
in terms of the joint venture agreement, and especially in terms of Article 7.1, the petitioner was to the company was supposed to the company was supposed to open 2 bank accounts, one for receiving payments from all the clients, which shall be referred as the primary bank account, and another account for the day-to-day operation of the company to be referred as the secondary bank account. Full stop.
देखो
Learned counsel for the petitioner contends that as far as the primary bank account number is concerned, he was supposed to be the sole authority to operate the primary bank account. Full stop. He states that the respondent breached the terms of the joint venture agreement and the said primary account was never operated by the petitioner. Full stop. Petitioner states that the fund which has been invested by the petitioner is duly admitted by the respondent in his affidavit of opposition. Full stop. He has drawn the attention of this court to the bank statement of the company, which shows that on 28th, on 29/8/2025, an amount of rupees 4,86,126 was deposited in the account of the company, and that the respondent had withdrawn an amount of rupees 2 lakhs and 2,86,500 subsequently from the account of the company. Full stop. He states that the respondents are operating the funds of the company on their whims and fancies, and that the petitioners, and that there has been a breach of the terms of the joint venture agreement. Learned counsel for the respondent states that the respondent number 4 had not signed the joint venture agreement, and that the signature on the joint venture agreement of respondent number 4 has been illegally procured. Full stop. Though the respondent doesn't deny that they had entered into the joint venture agreement with the petitioners. Full stop. From a side, this court is of the opinion that the petitioner had entered into the joint venture agreement and had deposited an amount of rupees 10 lakhs for running of the company. Full stop. It is further noted that in breach of the terms of the joint venture agreement, the respondent had not opened the primary bank account in the name of the petitioner and has been operating the account on his own, which on his own. Full stop. The amounts received by the clients are being utilized by the respondents, which causes threat to the investment of the petitioner. Full stop. The petitioner states the withdrawal of the money can cause irreparable loss to the petitioner as far as his investment is concerned. Full stop. In view of the facts of the case, this court directs the respondent to secure the petitioner by way of a bank draft in favor of the Registrar General of this court. The same shall be put before with a nationalized bank till the constitution of the arbitral tribunal for an amount of rupees 10 lakhs. With the above direction, the present section 9 application is disposed of.
Grateful, man.
Registrar. It's taken on record. Affidavit filed by the respondent is taken on record.
Whether that affidavit was filed be taken on.
Taken on.
Grateful, man.
Next.
Please, my lord, this is my section 9 application, my lord.
Yes.
By your lordship's order of November 26, 2025, my lord, an interim order was passed, my lord, and a special officer, my lord, was appointed, my lord.
I'm appointed as a receiver.
You're the special officer.
Lordship.
Are you filing the report?
Lordship, I have been intimated on 17th December. I called for a meeting on 19th December. There was a demise of my father on 14th December, so I was busy in his last rites and rituals. So I have decided, I have also intimated the parties that before 27th December, I cannot proceed for the visit. But I have called for the meeting on 19th December where we have decided, decided the visit, and I have also requested the petitioner to provide me the email ID and contact details of the respondent. They have provided me on 5th January. I have also intimated the respondent and the petitioner. I have intimated for the next for the next meeting that will be held on 11th January. Lordship, so
Yes, Mr. Sen.
My lord,
by
standing at the moment, only the interim order may be extended, my lord, till such time, my lord, these formalities can be dispensed with.
yes, Lordship.
In any event, my lord, the 90-day period is not expired, my lord. We'll take steps, my lord, in the meantime to issue Section 21 notice and steps.
Learned counsel for the receiver. The receiver states that she will be proceeding in terms of the order passed by this court dated 26 November 2025 and shall file a report within a period of
Lordship, 3 to 4 weeks.
within a period of 4 weeks. Full stop. She has to go and take possession of the.
Yes, ma'am.
You have to do that
Yes, ma'am.
within a period of 4 weeks. Full stop. The interim order granted earlier is extended further for a period of 6 weeks. 6 weeks, Mr. Sen?
My lord.
8 weeks for a period of 8.
I have a request, Lordship, if Lordship modify the order and also add police assistance.
Needless to state, the officer in charge of the concerned police station shall render all necessary assistance to the receiver to carry out the orders of this court.
My lord, the interim order, my lord, may be extended.
8 weeks.
I'm deeply obliged.
Great.
Deeply obliged.
Listen. 8 after 8 weeks.
This is my Section 9 application, my lord. Coming up for the first time, my lord. Petitioner is the contractor under the railways. He is not manufacturer of not concrete sleepers. These sleepers are used not for the purpose of binding the railway tracks.
Yes.
An agreement was entered into 1986, my lord. He will manufacture the sleepers and supply to the railways, for which they will give a land on license basis to the petitioner. Pursuant to that contract, my lord, license was given to me, which is at page 17. 2007, my lord, it was renewed.
Who appears for the respondent?
But, first time, my lord, we have not.
First time. Serve them. This
The only
is-
difficulty, Section 11 also we moved. We served, they did not appear. It was again adjourned. So some limited protection because they have raised
Not
a
at
bill,
this-
my lord, for a new rate, which
Not at this stage.
kindly my lord, give a short date, my lord. Then I'll come back after service.
The petitioner has preferred the present petition under Section 9 of the Arbitration and Conciliation Act, seeking a restraint order against the respondent from taking any punitive action in terms of the, which is the letter?
So later is at page 107, my lord. Raised a bill and asked us to pay, my lord. We want stay of this because not as far as this rate will not apply to us because previous contract was renewed.
In terms of the railway board letter number. This is
3rd March is not page 75 and 6th October is page 107. 2 letters.
1st March is
3rd March 25 at page 75.
page 75.
Page 75. And followed up on 6th October. Page 107. 2 demands raised. 75 and 107.
Railway Board letter dated 14/10/2022 and 3/3/2025. Right? These are the two
My lord,
letters.
these are two.
List this matter after 2 weeks.
2 weeks.
After 2 weeks.
I'll come back.
Lordship, I appear on behalf of the petitioner.
But I'm for the respondent.
Yes.
Lordship, my case here is that,
What is this application?
Lordship, under Section 9, Lordship, we have filed this Section 9 application. Hey, I'll give a brief fact to your Lordship. Lordship, they had availed a loan of 14.23 lakhs from our company, from the petitioner, and for being desirous of purchasing a vehicle, which is mentioned, your Lordship, comes to page number 3, your Lordship. At page number, at paragraph number 3, the particulars of the vehicle are given there. Lordship, the loan agreement was executed on 31st July 2019. However, your Lordship, they started defaulting. Subsequently, the loan was terminated on 30th November 2023, which is explicitly mentioned in paragraph number 7, your Lordship, at page 4. Lordship, then we entered into an arbitration, and then an award was passed in our favor. Subsequent, Lordship, this is a post-award Section 9. Lordship, in the award, we were given a first charge over the vehicle. The Lordship, that's explicitly mentioned in page number 34. Lordship, if comes to page number 34, paragraph 22, B, your Lordship.
Yes.
Lordship, and the receipt to that effect that they had received the award is at page 37 and 38. Lordship, the track reports explicitly states that they have received the award. Lordship, my prayer in this application is very limited. Your Lordship, the vehicle is lying with them. I want a receiver over the vehicle. Your Lordship has the jurisdiction to try and entertain the application. I'm before your Lordship for this limited protection. Till the time, your Lordship, I'm filing the execution application before your Lordship. I want this limited protection for my client.
Yes, Mr.
My lord, only two aspects. First aspect, my lord, is the award itself. A, unilateral appointed arbitrator, number one. Number two,
have you challenged it?
Yes, 34 pending in the city civil court. So under 42, even a 9 would ideally lie there and not before your lordship. That's, my lord, my demurrer. But, my lord, that apart on merits, my lord, unilateral appointment, completely ex parte, no 21 notice, my lord, no declaration under section 12. The arbitrator is somebody who's manufacturing, my lord, award after award for this same company. I mean, I can recognize his name. My lord, copy paste awards one after the other. In fact, no reasoning given in the award as to how this amount is due. Just because it's stated in the claim, the amount has been decreed. Bank statements not proven. My lord, only on the basis of statement of accounts. And my lord, my instructions are that out of the 14 lakh rupees, my lord, a majority of the amount, my lord, has been repaid. My lord, not a trace of, my lord, how much I have repaid, how much I have, my lord, not repaid. My lord, if they want to settle a matter, I understand, my lord, they approach us and, my lord, they discuss a settlement, my lord, that's a different thing. But, my lord, to obtain this kind of an award, and, my lord, my 34 is pending before the city civil court. So, my lord, there's concurrent jurisdiction, my lord, before your lordship and before the
I
current
would
city
have
civil court.
apprised your Lordship on that point as well, Lordship. The concurrent jurisdiction aspect, your Lordship has the jurisdiction to try and entertain the application.
No, my lord, if a 34 has been filed, it is a prior application under part 1.
Lordship, the 34, when they had filed that 34 before the civil court at Calcutta, your Lordship, tell them to give effect to that. Lordship, we have not been served with a copy of the application as well. Lordship, in that
application and we have not been there. I have to take instruction with relating to the pendency of the 34.
Take instruction.
Lordship, that's the first aspect, Lordship. And the second aspect with relating to this not having their claim, Lordship, they had defaulted. That's the only reason there's this outstanding.
Kindly, my lord, see, I
Lordship,
mean,
there's a clear default on their part. That's the only reason there's an outstanding of 10 lakhs against them.
Is it maintainable here?
Lordship has concurrent jurisdiction prior and entertain this application, Your Lordship.
my lord, several courts may have jurisdiction.
Lordship, let them come by way of an affidavit in opposition to this effect.
arbitration. But if one court having jurisdiction has been approached by a party, all subsequent applications, my lord, ought to go there. And here, my lord, is a challenge to this award. And the entire, my lord, case is based on this award, which is a complete sham. My lord, kindly
we are
may I-
not getting into the award, Mr. Almane. The award is not before me. We are not looking into
Understandable,
34.
my lord.
I'm only
In fact-
looking into protecting the property of the, the award holder.
Let them, my lord, take instruction then on the
Lordship, let them
aspect
come
of
by
the
way of an
34.
affidavit in opposition to that effect, stating all
You make
their
a statement,
allegation.
you will not sell the property, the vehicle. What? The issue is over.
Lordship.
You make a statement that you'll not.
Let my advocate on record make that statement, my lord. Are you sure?
Yes, 100%.
Yes, my lord.
Enjoy, but we will not sell.
Then I can dispose of the section 9 with that observation.
Lordship, let that undertaking be there that he'll not dispose of this vehicle.
Client is then court.
100%. How? Kind of one instruction.
Right.
बोल रहे हैं. One instruction.
I have not met the client, my lord, so
Yes, yes, this is not.
The petitioner has preferred the present post-award application under Section 9 of the Arbitration and Conciliation Act 1996, seeking appointment of a receiver to take possession of the hypothecated vehicle being 1412 HTLB 4200mm bearing registration number WB19K 2682 and ये पेज 3 से पैरा 3 से ना मार्क पोर्शन देख लेना चेक कर लेना इंजन नंबर 497 TC41 TPY 808645 and chassis number MAT 5440647 sorry K7 CO 5414 ये चेक कर लेना and further seeking an order restraining the respondent from dispossessing of, alienating, encumbering, or otherwise dealing with the said vehicle. It is the case of the petitioner that he had sanctioned a loan of
14 lakh 23,000. 14 lakh 23,000, Your Lordship. It's at page 3.
Wide loan cum hypothecation agreement dated 31st July 2019 in favor of the respondent. Full stop. As per the terms of the loan agreement, the respondent was supposed to return the loan amount by way of 70 monthly installment at the rate of rupees 32,054. Before 28th till 28th May 2025. Full stop. It is the case of the petitioner that the respondents defaulted in the payment of the said loan amount. Full stop. He further states that arbitration proceedings were initiated. Full stop. Wide award. What is the date of the award?
Lordship, it's 10th April 2024.
Wide award dated 10th April 2024. The respondents were liable to pay a sum of rupees 10,96,699 to the petitioner. Full stop. Further, first charge was created on the vehicle vehicle bearing number so and so, so and so. Full stop. It is the case of the petitioner that he fears that the said vehicle will be sold or third-party rights could be created as far as the said asset is concerned. Full stop. Learned counsel for the respondent appears and states on instruction that no third-party right, that he will not sell the property and no third-party right shall be created. Full stop. But still, I should go ahead and appoint a receiver so that the property is
Lordship.
taken and
Milord, then,
appropriate actions are taken.
Milord, then, Milord, I would like to bring on record my bank statements to show, Milord, how they have, Milord, suppressed the money that I have paid them, Milord, from time to time. Number one. Number two, my 34 is pending, Milord, where I'll inevitably, Milord, succeed. Milord, given, Milord, that it's a completely unilaterally appointed arbitrator, and the same arbitrator, Milord, even the punctuation errors, Milord, in several awards are, Milord, similar. And, Milord, it's a standard form award, just like the standard form contract. Milord, the bank statements have not even...
Unilateral appointment.
Yes, my lord. The agreement says that they have a right to appoint.
Let my senior, learned senior friend.
My lord, if your lordship considers for a moment, kindly, my lord, see the agreement at page 24, clause 29. Sole arbitrator to be nominated by the company. They are the company. And then when your lordship will see the award, my lord, in the award, my lord,
yes,
it says by letter dated so and so, the Council for National and
which page?
my lord, page 31.
Yes.
The award.
By letter dated 1612.
The Council for National and International Commercial Arbitration refer the disputes to me. My lord, he's the arbitrator in every matter for this company. How did he get appointed by this entity? Where was the section 11? And then, my lord, kindly consider the next page, 8. Paragraph 8 of the award, being satisfied that I have been nominated to act as arbitrator in terms of the arbitration clause contained in the agreement. And the arbitration clause in the agreement, my lord, refers to, my lord, the company appointing the sole arbitrator. My lord, we didn't even have notice of this arbitration. We learnt about it, my lord, when the award was served upon us. My lord, we have been in the dark about this. And, my lord,
you'll be satisfied, right? You don't
Lordship.
want to sell the property or the asset right now.
Lordship, I do not want to sell the asset right now, but
So you'll be satisfied with the statement, then we can dispose it off.
Lordship can dispose it off. But I have few submissions to make with regards to
in 34. Not
Lordship, not here, your Lordship. If he considers that he'll succeed, Lordship, 10th April was the award.
34 petition, whatever.
Yes, your Lordship.
Unilateral appointment, illegal appointment, all that you.
Yes, by consent, the certificate can be out tomorrow.
You can do that, your Lordship.
Yes, my lord. Your lordship, my lord, consider, my lord.
The 34. No question was considering the 34. All right. In
your lordship, can, my lord.
In view of the statement made by the learned counsel for the respondent, the petitioner does not. The petitioner states that his relief stands satisfied, and he does not wish to press the present Section 9 petition at this stage. The application is disposed of in the above terms.
My lord, my undertaking is without prejudice to my rights and contentions, and the fact that I'm disputing, my lord, the entire liability.
Do all that before your 34.
My lord, I have given an undertaking, my lord. That undertaking should not, my lord,
undertaken is only to the extent that you're not selling the property.
and that is without prejudice to my rights and contentions. My lord, kindly record so, my lord, because that's the instruction from the client, my lord. That without prejudice, because this undertaking should not spoil a case, my lord, elsewhere. Kindly.
Without prejudice to his rights and contentions.
I'm so grateful.
Undertaking and require. He will not sell the asset, which is the property.
Lordship, it's not about selling the asset. Lordship, the thing is that they change the nature and character of the asset. It actually is sold in parts.
Sell what?
If I can't sell it as a piece, as a whole, how can I sell it as piece?
No, you're changing the nature and character. I have seen in.
Well, the car will make a tempo.
Lordship, they do it. They change the entire chassis. Your Lordship.
Removable property that I'll convert a showroom into a Flat or
The
something like that.
Jabolika, the respondent will not sell the property, neither create any third party right, nor change the nature and character of the
Lordship. Lordship, the notice of motion and the affidavit of service may be kept under. Much obliged, your Lordship.
Grateful.
This is my application under section 9. Well, this well, the Lordship had on the 10th of December granted me 2 weeks' time to file my reply to the affidavit in opposition in the matter. Well, I understand the reply is not yet ready. Well, it is ready, but well, the client has not been able to come and affirm it. Well, that is the only difficulty. However, well, my predicament is well, the interim order is still today. Well, I am prepared to argue out the matter even without the reply. But my lord,
The opposition was served in August 2025.
no, that's right. I am not disputing that. I'm ready to argue out the matter even
Complying
without
with
my
the
lord.
interim orders.
Well, if your lordship, my lord, so my lord deems fit, my lord kindly gives me a week, 1 week, 1 week's time, my lord, I shall file the reply. And the interim order may be suitably extended, my lord, till whichever time your lordship deems fit.
interim order, then I'll extend for learned counsel for the petitioner seeks and is granted one last opportunity to file his reply to the affidavit in opposition within a period of 1 week, right?
Yes,
Within a
ma'am.
period of 1 week. The interim order granted earlier is extended further for a period of 4 weeks. 4 weeks.
Very grateful.
When do you want?
My lord, we your lordship's convenience.
List
My lord,
after
after
3
1
weeks?
week, any time, my lord.
2 weeks? After 2 weeks?
Yes, my lord.
2nd February?
Grateful.
Okay.
2nd February.
2nd February. Very grateful.
Grateful.
My airdrop code.
Yes, Mr. Mitchell.
Well, here I am for the petitioner. Well, in this matter, an interim order was passed in their presence on 18th of September 2025 when they were given time to file their affidavit in opposition, which was to expire sometimes on 7th of November. Around. Now, on 3rd of December, the next order was passed when they took extension to file the affidavit in opposition. That was filed on that date. I was to file my affidavit in reply. I was smiling because, my lord, I was about to make the similar prayer, man.
I cannot stand in the way.
So how much time do you need?
My lord, it's with me, to be very candid. My lord, I would, stick 2 weeks time, my lord, so that.
And when is the interim order expiring?
It's expiring, my lord, 6 weeks from 3rd of December, my lord, it comes to koto hocche.
Then it would go till almost February.
Yes.
6 weeks means Feb, I guess. No.
No.
End of Jan. This third. So third would be Jan.
4 weeks.
Around the
second week of
No, it's
January.
possibly 14th, yes, 14th of January.
Then I'll extend the interim order.
Okay.
Take down. Learned senior counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the affidavit in opposition. Interim order granted earlier is extended further for a period of 4 weeks. List this matter. When do you want?
Well, it can come up on the 2nd of February. My lord.
2nd of February? 2nd of February.
Okay.
My lord, in 9, my lord, I am appearing for the applicant. My lord, in this matter, my lord.
I am applying for the respondent. I am being led by Mr. Sarvapriya Mukherjee. Is there online?
My lord, I am, my lord, only praying.
my lord, we have to file a supplementary affidavit. My lord, some documents which were used in the arbitration itself, my lord, could not be annexed. My lord, we only want to file the supplementary affidavit, and my lord keeps it, my lord, any my lord, after my lord,
supplementary affidavit
because my lord, lot of documents, my lord, have
Although
been.
they have not filed any of the documents, in fact.
Yes, my
In
lord,
fact,
but to, my lord,
pleading
place
in
it
the
on record.
petition is that they don't possess the records of the arbitration proceeding.
My lord, we have sought for the, my lord, copies from the
file
learned
a
arbitration.
convenience compilation set for the court.
Yes,
Very
my
well.
lord.
That can also be done, my lord. But my lord, we have already created reference. Very well, as your lordship.
It's a fresh 34, right? Within
Fresh
time.
34.
Within
Fresh
time.
First time it's appearing. First time it's
First
appearing,
time.
my lord.
First time.
Within time, right?
Within time, ma'am. Within time.
The petitioner has preferred the present petition under Section 34 of the Arbitration and Conciliation Act 1996, challenging the arbitral award dated
Arbitral award, 8th August 2025.
8th of August 2025, passed by the arbitral tribunal. Full stop. The parties shall file a joint convenience compilation set within a period of 4 weeks.
4 weeks.
4 weeks. List this matter in the monthly list of March.
Very well.
March.
Grateful.
Oblige, my lord.
Grateful.
Namdar.
Lordship, may it please my lord, I am appearing for the petitioner in item number 10. This is my lord, my 34 application that is appearing for the first time. My lord, I am the award holder in the arbitral proceedings. My challenge to the arbitral award, my lord, is limited to the point of non-grant of interest by the learned sole arbitrator. That is, my lord, for the pre-award period.
Your
May I?
Lordship, here for the respondent, Your Lordships. I am seeking 4 weeks of time to file my reply, Your Lordships. Also, a small request, Your Lordships. There are 2 APs. I have also filed an application for challenging the whole arbitral award. Your Lordships may kindly tag both the matters and list the matter for hearing.
Where's the other AP? It's been
AP
filed?
9, Your Lordship, it was heard. And Lordship,
It's appearing, I understand, as item 153 of my lord's monthly list.
AP 935 of 2025, Your Lordships. Also, Your Lordships, AP 720 of 2024 was also filed, Your Lordship, challenging the interim award. So, Lordships, all the 3 APs can be heard together, Your Lordships.
So give the AP numbers.
AP number 720 of 2024 and AP number 935 of 2025, Your Lordship.
930?
5 of 2025.
One humble submission, my lord.
AP number, just 1 second. AP
Yes.
number 720 is the 34 petition, right?
It is the 34 challenging the interim award. And 935 is challenging the final award, Your Lordship.
Yes, madam.
One submission, my lord, in respect of the 34 by my learned friend on the other side, challenging the final award, there were directions for filing of the arbitral records by way of an affidavit in opposition. Now, my lord, that exercise, my lord, kindly extends my time by 2 days. The compilation along with my affidavit in opposition shall be filed with the department.
That is not listed today that I can do that.
My lord, it is, I understand, subject to correction, item 153 of my lord's list, monthly list.
Monthly.
It can be treated as on the day's list, my lord, and necessary orders may be passed.
153 is Shohrab.
Yes, ma'am.
Monthly list.
And my lord, since this petition is limited to the challenge on the point of interest, my humble submission would be that perhaps 4 weeks for an opposition on this point would be a little too much, lordship. I bow down to whatever time.
If you are in your 34, you are filing the affidavit in opposition, bringing all the necessary arbitral records. What's the
Yes.
point of affidavit in opposition?
Yes, my lord, that is my prayer in this is my 34.
The 34 is being treated here is like a writ petition, affidavit, reply,
My
opposition.
lord, I am not, my lord, this is my 34. My learned friend just now made a submission that she wants 4 weeks to file an opposition to this.
That's
I'm
regards
opposing
1
that,
week.
my lord. I'm opposing that prayer.
State on the petitioner has preferred the present petition under Section 34 of the Arbitration and Conciliation Act, challenging the arbitral award dated
August 26th.
26th August 2025, passed by the arbitral tribunal. Full stop. Learned counsel for the respondent seeks and is granted 2 weeks time to file his affidavit and affidavit in opposition. List in the monthly list of March. It's in the
If we
monthly
request
list
for
of March, along with
February, it can come.
along with AP number 720 of 2024 and AP number 935 of 2025. First time.
My lord, if it comments to my lord, may it be the monthly list of February? Because my lord, I can file the compilation within 48 hours from today. And then, my lord, all APs will be ready.
Monthly list of February.
I am deeply obliged, my lord.
Monthly दिखा दो.
Wait for your choice.
I don't know, 35. This is my section 9 application.
Yes.
The other section 9 application, my lord, which is item number 17 of the monthly list. Yesterday, on Monday, Lordship has passed an order and kept it with the, my lord, monthly list of February. There they were supposed to file a rejoinder, I think, my lord. Here, my lord, I have to file a reply. So, my lord, this can also be kept with the same, my lord, monthly list. Same group company and my claims are the same. Facts are identical also.
So monthly list of February.
Yes, the other matter they have prayed, Lordship has kept it. This can also be heard out together, my lord. In the meantime, I'll file my reply to their opposition.
Learned counsel for the petitioner seeks and is granted one last opportunity to file his reply to the affidavit in opposition. List in the monthly list of February.
Great.
This is
Item 36, I am for the petitioner.
Yes. Lordship, in this matter, we already had an interim order. Lordship, a section 21 notice has been sent, but we have to take steps for section 11. That has not been done. Lordship can dispose of the application as of now.
Dispose of the application with.
Lordship, if the interim order could be kept for a month.
That's a problem. Then disposing of right now with that direction will not be appropriate.
Lordship, we are taking steps for the 11 to be filed.
And I'll keep it after
Lordship,
2 weeks or 4 weeks.
4 weeks, Lordship will do.
At the request of the learned counsel of the petitioner, let this matter be listed after 4 weeks.
No.
4 weeks. Give a date. Just give a date. 4 weeks.
Lord, next matter, my lord. I appear, my lord, for the respondent. Lord, I have a very bad throat, my lord. I am leading Mr. Kabir. My lord, kindly keeps it on the next day. This is post affidavits, my lord. At the ad interim stage, my lord, interim order was refused. And they have annexed some new documents.
You're not
my lord.
arguing the matter, madam.
No. Next
One
week, I'm
application
asking for an adjournment. And Milord, in their reply, they have annexed new documents. I want to, Milord, file a rejoinder to that. Kindly gives me 3 days, Milord. I'll come and, my lord, kindly, my lord.
Things are complete. I don't think, my lord, there's any scope of, my lord, having, my lord, further pleadings.
Ms.
My lord,
Banerjee,
my
I'm filing
application,
my
my lord,
affidavit.
under section 9, my lord, with regard to, my lord, asking, my lord, for certain, my lord, interim orders in connection, my lord, with an arbitration agreement by naturally, my lord. And, my lord, my lord,
My opposition is there. I've already served them, my lord.
Yes.
affidavits
Sir,
are
I'm only asking for a few days so I can respond to Mr. Banerjee's submissions. That's all, my lord. Then they have annexed, my lord, some new documents. If your lordship allows, my lord, I'll deal with them in their reply. Or, my lord, I'll just come and
Her
defend. But
throat is really bad. You're pushing her. We'll have it next week.
kindly, my lord. Grateful, my lord.
We'll have it
Lordship,
next week, my lord, then, my lord,
when do you want it?
my lord, my lord, any day, my lord, convenient, my lord, right?
Your lordship kindly takes note of my filing of my opposition.
Reply file code is it? My lord, we have already filed our reply, my lord.
And my lord, time for rejoinder, my lord, as paid by Mr.
No, my lord, that's
Banerjee.
Since they have annexed a new document, my lord, I am.
My lord, only the balance sheet, my lord, of the
Yes, so, my lord, 3
letter.
lines I'll deal with that. That's it.
This is your affidavit.
This is my affidavit in opposition.
Opposition.
Opposition is taken on record. File affidavit in opposition filed by the respondent. Full stop.
14th. 14th.
Let this matter be listed for hearing. Mr. Banerjee, tell me when do you want?
My lord, subject to my lord's convenience, my lord, 15th January, my lord, if it's possible.
15th is a Thursday. That's execution days.
Then, my lord, 19th.
19th, yes. We can have it on the
Reply
19th.
rejoinder.
19th, we can have it.
But in the meantime, I'll use a rejoinder, my lord. Is only to deal with his affidavit in reply. There are some new documents, my lord. I'll just deal with that.
Not even
I will not annex any new documents.
Annual return, my lord, is only there.
You could have
Yes, and that is the
Was
crux
filed
of the
earlier, then
matter.
the reply in answer to the opposition, they filed a reply annexing.
A
some new
reply will have a surrey rejoinder.
No, I'll just use an affidavit to deal with that. Before that, my lord, we'll come up and we'll serve well in advance.
Well, I'm opposing, my lord. Any, my lord, pleadings are already, my lord, completed. My lord, this is a matter, my lord,
What
pending.
new document you have filed?
My lord, annual, the financial statements. My lord,
Their balance sheet, my lord. Which
So
we
why,
are not, which
it's
we are
a
not.
matter of record balance sheet.
Yes.
Yes.
Why are you opposing that balance sheet? It's a matter of
I'll tell your lordship, my lord. Our allegation, my lord, is that they have, my lord, changed their shareholding pattern. They have annexed an old, my lord, balance sheet wherefrom it is
There's a loan
evident.
agreement, my lord, of
That is the main crux of the
If it
matter.
is going to merits, my lord, I can also, my lord, start my
No,
application.
I
But,
am
my lord, we are
just
not going into it.
How is he prejudiced, my lord, if I file an affidavit? That's all, my lord. Let it. Yes.
learned counsel for the respondent seeks and is granted 1 week time to file reply to the rejoinder to the
No,
reply.
Rejoinder to the affidavit.
Rejoinder to the
Affidavit.
affidavit in reply.
Grateful, my lord.
19, my lord, is kept.
19.
Grateful.
19.
19 January.
Kumarjit. But I was appearing, my lord, with Mr. Kumarjit Banerjee, whom, my lord, I don't see, but he's on his way.
Just give his
I'm great.
Grateful, my lord.
Statement I have for the petitioner, my lord. Previous occasion, lordship directed the parties to exchange affidavits. The opposition has not yet been filed over my application.
Who's on the other side?
My lord, Section 9 application, my lord, interim order was refused at the ad interim stage. And the direction was there. I have approached against the protection of my security deposit, which was alleged to be forfeited. My lord, the termination has been illegal. My lord, it's divorce provisions.
Nobody is here today.
Kindly adjourns it for 2 weeks, my lord, then I will serve them notice further to appear. I will again
At
serve
the
notice.
request of the learned counsel for the petition, let this matter be adjourned till
1 week, 1 week.
28th January.
28th January. File my affidavit of service, my lord. I forgot. Affidavit of service. 20.
Affidavit of service taken on record.
My lord, in this matter, my lord, I am appearing with the of the petitioner, my lord. It's my section 14 application. My lord, on the last occasion on December 1st, my lord, your lordship has directed the respondent to file a opposition in this matter, my lord. They have not filed yet, your lordship.
Lord, I am appearing for the respondent. Lord, I was just humbly praying for one, my lord, humbly making one submission, my lord. May this matter appear tomorrow, my lord. We will not file an affidavit, my lord. Your lordships can consider hearing the application. But I'll want to do this matter physically, my lord. I was humbly making this submission, my lord.
Not today.
My lord,
Great.
in that even, my lord, tomorrow is, I have some difficulty, my lord. I have fixed matter, my lord, in the morning, my lord. Friday, lordship kindly keeps this matter, my lord.
Very well, my lord.
Not today. Keep it 13th.
13th. Not this week, your lordship is making. Grateful.
Grateful, my lord.
Yes.
I am for the respondent.
This has been going on, right?
Yes, this matter, your lordship was hearing my other side.
Yes.
Probably they finished. I am told, my lord, they have concluded.
We can start.
I'll come back next week for that.
None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed next week.
Next week, my lord.
So we'll give a date only, Mr. Sen.
Wednesday.
Wednesday, 14th.
Yes. 2 p.m. will it, my lord, be good?
Don't fix a time. It's difficult. 14th.
14th.
Well, this is a section 34 application, lordship may remember with that, my lord, Eastern Railway.
Eastern Railway.
Yes, my lord. My lord, today, my lord, I have a little difficulty. My junior, Mr. Huck, has a bereavement in his family. Any day, lordship fixes, even tomorrow or day after, any day, my lord. I really want to finish it off, my lord. I think Mr. Mukherjee is on the other side. He had some problems on the, my lord, fixing it. Any day, my lord.
Yes, Mr.
No difficulty, my lord.
Tomorrow, day after, today, I...
Some legs I can't stand it.
So we'll have it tomorrow. We have that.
Any day, my lord. Today, since there is a bereavement in his family.
Mm-hmm. 14th?
Yes.
14th.
Grateful.
At the request of the parties, let this matter be listed.
Great.
Well, this is
Now we can hear that.
This is that matter.
After that.
This is now on the merits, my lord. I will get a chance to argue the matter on merits.
You changed my mind.
This is an advantage of arguing before a open-minded court. Well, this is an appeal against the 17 order.
Where are they?
That is the problem, my lord.
Because this is.
I will be very cautious, my lord. I know the limitations of a 37. And I will only stick to basic principles of injunction and order 35. Because, my lord, I will show your lordship, my lord, if the tribunal has held in one order that there is no case of attachment being made out in the same, for the same parties, for the same facts, you are not giving an interim award, but you are saying deposit the security. That is contrary to, so that is a basic thing.
Let them come. This is
yes,
a. This is a.
Then, my lord, may I say this, my lord, kindly fix this matter. My lord, this is because we are before the tribunal, the evidence is going on. And I need to, my lord, change the mind of the tribunal. I am a late entrant there. Matter has proceeded long before that. There has been some prejudicial acts done. Maybe my client may not have complied with an earlier direction. And everything is proceeding on prejudice. So,
when do you want?
Not Tuesday, my lord.
Tuesday.
Because I don't know whether Friday if matter will okay, nahi? Friday.
Friday don't.
No, Tuesday.
Tuesday. Take down. None appears for the respondent. At the request of the learned counsel for the petitioner, learned senior counsel for the petitioner, let this matter be listed on 13th.
Well, let it be slightly in the supplementary list, because then, my lord, I get a first chance to finish the matter. Obligement.
My appeal under section 37 from an order purportedly passed under section 17. The order is at page 15, completely unreasoned. There is already a stay in respect of this order, my lord.
Who's on the other side?
Just say never
My
appear.
lord, item number 42, my lord. My lord, item number 42, I'm appearing, my lord, for the respondent.
All right. At the request of the parties, there are none for the respondent. Those. At the request of the parties, let this matter be listed. We're keeping it on the 13th, right? 13th. 13th, madam.
13th, my lord. Grateful lordship. 30. Grateful, my lord. Grateful. Okay. Huh?
Is this coming for the first time?
No, my lord. This has come, but there has been on a prima facie satisfaction. This honorable court, Honorable Justice Shobhushachi Bhattacharya, when he was sitting in the single bench, had passed an order of stay in respect of the impugned order, my lord. Impugned order that is at page 15, my lord. Starts from page 15. No section 21, nothing. No service of statement of claim, no service of section 17. Suddenly an order, completely unreasoned order under section 17.
Arbitration clause. How could you pass that?
And we have, and it's our specific case that there is no arbitration clause between the parties. This says on perusing all materials and agreement, the order is passed under section 17, the following order. And a 4-line order. No reasons, nothing.
Page?
No service also.
No service of section 17. We have served the stay order pursuant to the honorable court's direction. They are still not appearing. On the last occasion, my lord, affidavit of service also was filed, my lord. They are still not appearing. And even after this, there is no notice of the arbitral proceedings. I do not know what is happening.
Can't have it today. I have to go for a division bench.
No, it has
We'll have it not today. I have to go for a division bench. I'll be back after that.
I appear for the respondent.
Lordship, I'm for the petitioners. I'm praying for an adjournment for a month because Ms. Srijani Mukherjee, appearing for the petitioner, she's suffering from chicken pox. And is
Chickenpox?
Yes, and she's very, very weak. So it
Proxy
will.
counsel so and so. Ria.
Your Lordship,
Yes.
Your Lordship,
this is appeal under section 37, my lord, and they have also filed a stay application. So if my lord directs, I can come up with an opposition in closing the documents. Their grievance is that the reference notice was not served and they were not aware. However, this is incorrect, my lord. They have suppressed. They filed suit, obtained injunction,
We'll see that.
and then failed to comply.
Proxy counsel so and so appears and states that the main arguing counsel is suffering from chickenpox. He prays for an adjournment. Let this matter be listed. After 4 weeks,
5 weeks, if it's
the monthly
possible.
list of February.
Your Lordship, item number 47 and 48 are also my same prayers regarding. It also
44,
been
47, 48, huh?
44, 47, and 48.
Call out 47. You are there in that matter, madam?
No, madam.
You are only in 44.
My lord, I am appearing for the respondent in item 48, my lord. May I have leave to appear virtually?
Call 45 first. Not today. 46.
Lordship, I am for the appellant in this matter. I am led by Mr. Abhijit Mitra. He is led for Barasat in some other matter. Can it be not today, Your Lordship?
What is this matter?
Your Lordship, this is section 37. It's a appeal from section 17 application for regarding possession of.
Readings are complete.
Readings are complete.
No, my lord. No, my lord. Pleadings are not complete. My
Your Lordship, readings are not complete. Sorry, Your Lordship.
Respondent, my lord. Is appearing for the first.
It's happening for the first time.
First time, my lord. Lord, if I may indicate the brief background.
Yes.
It's an ongoing arbitration proceeding, my lord, wherein, my lord, the subject matter of the dispute is regarding the, my lord, the tender concerning the repair, refurbishment and running of a thermal power plant. Now, my lord, because of certain disputes regarding supply of coal, arbitration proceedings have been initiated. And, my lord, at the fag end, my lord, right now, final arguments are going on. At the time of commencement of final arguments, my lord, the respondent in the arbitration proceedings had filed an application seeking possession of the thermal power plant, which was opposed by us. And, my lord, finally, the learned arbitrator has passed an order refusing to allow transfer of possession of the thermal power plant at the fag end of the arbitral proceedings. My lord, against that refusal to grant such relief, my lord, the appellants are before your lordships under section 37. So, my lord, we need to, if your lordships are minded to consider this application or appeal, my lord, then we'll have to file a response and, my lord, bring on record all the.
We'll
facts
see
that
that.
are-
The senior counsel is not here, not today.
Very well.
Your Lordship, my prayers for the item number 47 and 48 are also same as item number 44.
47, 45, cross. Correct, correct, correct. Exclusive डाल देना, none for the respondent. 47.
Item number 48, I am on behalf of the defendant, and my senior is appearing on the virtual mode.
Yes. 48, just give your appearance. 49.
Much obliged, Your Lordship.
Lordship, I am appearing for the petition. I apologize for appearing virtually. May it be taken up next week? I shall appear, assist your Lordship physically, Lordship. Any date next week, Lordship.
Not today.
I'm
Yeah,
grateful.
okay, for the respondent, my lord, there are only two difficulties. One, my lord, the arbitration proceeding,
We'll
my
see
lord, is
that she's appearing from the car.
very good. Yeah.
And madam, please don't appear from the car.
Yes, I apologize for this.
Have some respect for the court.
Yes, Lordship.
Next week. Not today.
Item number 50, I appear for the respondents. In respect to this matter, I would like to hand over a order dated 8 January 2024. The similar matter, my lord. There were directions upon the petitioner to take steps. No, this is in respect of item number 50 and 59 as well, madam. Lord, if my lord could come at the second page of that order, my lord. This is a commercial dispute. The steps were to be taken by the petitioner to convert the same. There were no step taken by them till date.
Who's there?
Bring for dismissal of this section 34 and 36. Lordship will kindly see there was an order on 8th of January 2024 which has not been complied with. This has been kept pending. Neither have they secured the amount. They're appearing in the execution application, which you will recall there was an order which is fixed tomorrow for examination of judgment letter. They filed their affidavit of assets, but they are not pressing for the section 34.
We'll have it tomorrow. Tomorrow we'll have it, not today.
Very well, Lordship.
This is the same MSME that.
Yes, Your Lordship will be aware that there's another judgment of Justice Moshmi Bhattacharya where it says that first you'll have to secure and only then.
You're 34.
50 and 59, then Your Lordship will kindly keep it tomorrow. 50 and 59. And 59.
59.
Both relate to the same award.
Okay.
One is 34, one other is 36. Grateful, Lordship.
They have not deposited the.
No. Nothing, Your Lordship. After that order, no steps have been taken.
All right. Execution is tomorrow.
Yes, Your Lordship.
We'll have it Friday. Friday. We'll have it on Friday.
Your Lordship will kindly pass a one-line order so that Your Lordship.
None appears for the.
Yes, Your Lordship.
None appears for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed next week now. Put it next week. You'll keep it next week.
Very well, Lordship.
13th.
Grateful.
One.
Manor, I pray for not this week, Manor. Not this.
Why? What happened? What is this?
Seniority in finance.
All right. Proxy counsel so and so appears and states. Yes,
Tomorrow they have to give a affidavit of asset.
I'm only concerned with this matter, not tomorrow.
In this matter only. It's connected to
That's
this
right.
matter.
That's the execution case which is coming up tomorrow.
Yes.
Nothing to do with this.
Grateful, Madam.
Proxy counsel so and so appears and states that the main arguing counsel is indisposed. Prays for an adjournment. Let this matter be adjourned for 2 weeks.
Lord, I have a question for the respondent.
They are asking for a date.
My lord, on the last occasion, my lord they had submitted that they would pay 75% of the entire amount. It fell from my lord that they have to pay the entire amount along with interest as deposit.
They said that they would come back with instructions. So, my lord, that's where the matter stands. The execution, my lord, is pending.
Let the execution be pending. I'm not granting any stay. Execution is there tomorrow. We'll go ahead with the execution.
My lord had passed a direction for them to file affidavit of assets.
What happened to the settlement talks?
My senior will come tomorrow.
After 2 weeks.
But I appear for the respondent. I'm opposing both the applications.
Lordship 52 and 53. Lordship, one is section 34 and one is section 36. Lordship, in this matter, Lordship, I am being candid in for section 36, Lordship. We are not in a position to deposit any money that is required for the section 36. In this matter, Lordship, we have taken time for talks of settlement going on, Lordship. This is the settlement that they have been proposed by them.
There is no
one way,
settlement, my lord.
Lordship, it is a one way going from that side.
This
We are
has
not
been
able-
adjourned at least, my lord, on several occasions on this pretext that it is being settled by them. And I have been saying there is no settlement whatsoever, my
It's
lord.
a one-way
Kindly let
communication,
us
sir.
proceed with the matter, my lord.
Lordship, in the light of this, Lordship, we have given this letter in November that we like to pay 80 lakhs by.
Proceed with the matter. We'll finish off the 50. One is 52 is 34.
Yes, my lord. And my lord,
30 to 30.
it's not maintainable also on the face of it, my lord.
Lordship, then kindly take in record, Lordship, that we are trying to settle in that one shot, Lordship, we like to pay the amount also, the 80 lakh.
Settlement
You're not making the payment, sir. That's what
Settlement
he's
is
saying.
out of court. My lord, I have a 4.5 crores award. Why should
Why
I
will they
settle
settle
for
it for
80 lakhs?
Lordship, resolution has been passed by them, Lordship. They have agreed, Lordship.
No resolution, my lord. I'm saying
I'll
this.
go by whatever he's saying.
Yes.
Lordship, the asset is also under their symbolic position, Lordship. The asset is also not used by us. It is remaining idle, Lordship.
Pursuant to directions of the arbitral
Arbitral,
tribunal, the receiver has taken possession, not us.
Lordship, so though income is also generated from the asset, Lordship, though it is in their symbolic position, Lordship, so the predicament is all, Lordship, in against ourselves, Lordship. We want to settle, Lordship, but
Where is the question of settlement coming on? It is a section 34 application is challenge the award. Let him proceed with the my lord, petition. And I'm saying, my lord, it is not maintainable also at this stage before my lord, the section 34 itself.
Yes. Yes, sir.
Lordship, that's in the section 34, Lordship, the sole defense in this is, Lordship, that award has not been.
462 is 34.
Yes, my lord.
APCOM 46.
Yes.
Lordship.
Yes, my lord.
Yes, tell me.
Lordship, the asset that we have got is the stone crusher. The company related is also doing the business relating to stone crushing business, Lordship. And the asset is utilized in Bihar, Darbhanga district, Lordship, near Jharkhand district in Bihar, Lordship. The award has been communicated to us, Lordship, but the kindly take, Lordship, page 21, para 34, Lordship. I will not take, Lordship, lots of time, Lordship. I will just remain to the fact that is the defense, Lordship. I will not take, Lordship, much time, Lordship. Page 21, paragraph 34. Lordship, the reason behind that we are challenging this award is this only. The main issue is this only, Lordship. The petitioner had no knowledge about the date of the award passed by the learned arbitral tribunal and did not receive any award copy, neither from the learned tribunal nor from the claimant. After filing the execution application before the Honorable High Court, Calcutta, by the respondent, the petitioner came to know about the award being passed by the learned arbitrator on 28 February 25. The petitioner received the execution application being so-and-so from the respondent. Thus, the petitioner had no occasion to gather knowledge about the said award passed by the learned tribunal until 28 to 25, when for the first time the petitioner received the said execution application. Although the inquiry internally, the petitioner came to know that one of the seasonal labor at the office of the petitioner, Hisua, Nevada, Bihar, Mr. Pandey, had received the award and had never handed over the same to the petitioner or any of the officer. Therefore, the petitioner was not at all aware of the award being passed. The petitioner stated that thus there has not been a delay in filing the aforesaid section 34 application under the Arbitration Conciliation Act. The maintainability point, Lordship, has been dealt by this, Lordship. Since the seasonal labor has received the award copy, he has not communicated this to the the permanent employees of the company, Lordship. This is the fact, Lordship. I'm not shying away, Lordship. This is the fact and circums of this matter, Lordship. We are not able to receive the award in this matter. In spite of that, Lordship, we have tried to settle. We have
That is
received.
the only ground?
Lordship?
The only ground?
Lordship.
That you didn't receive the award?
Lordship.
All right. The rest you're satisfied with the award, right?
Lordship, no, Lordship, since my learner senior has taken the maintainability point, Lordship, I'm dealing with the maintainability point first, Lordship, regarding this. Regarding the maintainability point, Lordship, I've been taking this.
When was the award received by your seasonal worker?
Lordship, on 28th February 25, Lordship.
Award was received?
No, Lordship, seasonal worker has been received, we don't know because he had not communicated with us. We have came to know from the execution application, we have to came to know. So when the seasonal laborer has received the award, we have no knowledge, Lordship. If we have knowledge that is right, Lordship, then we should have come earlier before your Lordship. If we have the knowledge. Only for maintainability point, Lordship, I have been first dealing with this only.
Award passed on 5/4/2024, right?
Yes, Malord.
When did you file it? 34?
In June, Lordship.
It has been filed, Malord, in
9th of June 2025.
2024.
2025.
Lordship, in February, Lordship, we came to know about the award, Lordship.
Excellent.
Since we have got the hold of the execution application.
All right. That's it.
Lordship, on maintainability point, Lordship, this much.
Not maintainable, yes, tell me.
Malord, kindly sees, Malord, how is it not maintainable on the face of it? Malord, first of all, Malord, this is a court-appointed arbitrator under a Section 11 application. Highly contested matter, Malord, a reputed senior of our High Court. Highly contested arbitration proceedings. They had contested 210-0.
Where is that, Mr. Banerjee?
Malord, kindly sees the award. The award has been passed. The award starts from page 24. And Lordship will find, Malord, the appointed arbitrator's name, Malord, at page, Malord, 36. Passed on 25th of April 2024. And it is not an ex parte order. Every, Malord, occasion they had contested it. Page 36, Lordship will find, Malord. Now, Malord, apropos this, Malord, the award was sent. We had written to this to the arbitrator. Kindly sees, Malord, the award was sent to them by postal receipt at the address under Section 3 of the Arbitration Act on 26/4/2024. And, Malord, they have received it. Well, I'm just making a mark, Malord, on 1st of May 2024. Kindly sees the records, Malord. We got it from the arbitrator. It to Devin. At the said address where the arbitrator has been, Malord, informing about all the minutes and, Malord, all the correspondence in respect of the same arbitral proceedings. So, Malord, the award gets delivered in, Malord, May 2024 itself, Malord. Addressee has received it at the said address. So, the 3 months time, Malord, starts from there and another 30 days, Malord.
Receive it on 26th of April.
Yes, Malord. Kindly sees, Malord, the date. It's been received on 1st of May 2024. 1st of May 2024, Malord. So, Malord, the 3 months time starts from then. And, Malord, expires after the expiry of 90 days. Another 30 days he gets a grace if he comes before my lord, and my lord could have satisfied my lord that there were reasons, my lord, for the extension of another 30 days. That has also expired, my lord. Now, when do they file it? My lord, kindly sees, my lord, the affirmation page at page 23 of his petition, 9th of June 2025. That's beyond the, my lord, 3 months period as well as the grace period of 30 days. Whereafter, my lord, lordship doesn't have any jurisdiction whatsoever, my lord. And, my lord, this paragraph 34, page 21, my lord, the, my lord, reason given that, my lord, Mr. Pandey had received the award, my lord. No date given, no affidavit filed by Mr. Pandey saying that, yes, I have received the award on such and such date. Just a mere, my lord, statement made from the bar. Whereas the arbitrator, my lord, has given the record itself, which shows that they have received it on the same address on 1st of May 2024 itself. So, my lord, on the face of it, the section 34 is not maintainable. On the face of it, we don't need to go into the merits of the case, my lord. And we have filed the execution proceeding, which is pending before my lord. In 2024 itself, we have filed it after expiry of the 4 months, my lord. So, my lord, therefore, this application on the face of it should be dismissed, my lord. Does not have jurisdiction, my lord, to be entertained at all, my lord.
Take down. There's nothing here.
Lordship, then kindly recall, Lordship, we are trying to settle and at one go,
No
Lordship.
settlement, my lord. No
Lordship, once,
settlement
Lordship, we are trying
whatsoever.
to settle and Lordship.
Settle it, sir. I am not
In the execution, if he comes before my lord and settles it, I have no issues, my lord.
Take
Lordship,
down.
kindly record, Lordship, the symbolic position of the asset is.
But it is pursuant to an order of the arbitrator.
There's a petition filed under Section 34 of the Arbitration and Conciliation Act challenging the award dated 5/4/2024. Full stop. The petitioner has filed the present petition much beyond the limitation period, i.e. on 9/6/2025. Full stop. It is the contention of the learned counsel for the petitioner that the petitioner had not received the award passed by the arbitrator. Full stop. He has merely stated in the body of the petition that one Mr. Ajay Pandey had received the award and the same was not communicated to the petitioner. He further states that the said Mr. Ajay Pandey was a seasonal worker and did not communicate the fact that the award was received in the office. Full stop. Though no affidavit of Mr. Ajay Pandey have been filed in this regard, neither any document has been placed on record to support the said contention. Full stop. Mere averment in the petition is not enough to support the said statement that the award was received by one Mr. Ajay Pandey, who is said to be a seasonal worker in the office of the petitioner. Full stop. It is further contended by the petitioner that he was made aware of the passing of the award only when the execution petition was filed on 28/2/2025. Full stop. Anything else?
Lordship directs, Lordship, then we can file a supplementary. We try to trace out Mr. Ajay Pandey since he's a seasonal worker. Lordship, see, we
should have done that before.
Lordship, give an opportunity, Lordship.
Oh, sir, sorry. Next. Learned counsel for the respondent states that this court, while order dated August 2025, had appointed the learned sole arbitrator Mr. Siddharth Mitra as the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. He further draws the attention of this court to the fact that the petitioner herein had participated in the arbitral proceedings and that the said award is a contested award. Full stop. He further states that the award was passed on 25th April 2024 and the same was communicated to the petitioner on 1/5/2024.
Received on 1/5.
And the said award was received by the petitioner on 1/5/2024. He has handed over. This is not part of the record.
No, my lord, they have not filed it. So
He
I
has
got it from the arbitrator
He has
itself.
handed
my
over a copy of the record of the arbitrator, wherein the arbitrator had sent the award to the petitioner by post on 26/4/2024, and the same was received by the petitioner on 1/5/2024. Full stop. A copy of the same is kept on record. A copy of the communication received from the arbitrator is kept on record. Full stop. In view of the fact that the petition is barred by limitation, this court has no jurisdiction to entertain the present petition. The same is dismissed on the ground. This is 30 plus
34, my lord. 34, my lord. 30 plus, my lord, another 30 days. 90 plus another 30 days. But, my lord, that threshold also, my lord, he doesn't qualify. That, my lord, expired in August 2024 itself.
The
My lord, kindly sees proviso to subsection 34(3), my lord.
It is last time. The present petition is dismissed in view of the section 34(3), wherein an application for setting aside shall be made within 3 months, and that a further extension of 30 days can be granted by the court. Full stop. In the particular matter, the said period, even if assuming the concession which could be granted by the court of 30 days has even expired, and thus the present petition is not maintainable, and the same is dismissed.
My lord, in view of this,
36 in view 36 में लिखना दूसरे वाले में. Since the 34 petition itself is not maintainable and the same has been dismissed on the ground of non-maintainability, the present application cannot be entertained and the same is dismissed for the said reason.
But this second part may be the order in the next AP, my lord.
Next AP.
Next AP.
Next AP. That's the order in the next AP.
Grateful.
That's in 36.
That's in 36 too, my lord. That is fine. Grateful.
Great.
Lord, in this matter, my lord, learned additional solicitor general will address your lordship, my lord. My lord, if your lordship can fix any date, my lord. My lord,
who will address?
Well, I am for the my lord petitioner here. I filed 36, also 34, my lord. 34 is appearing item number 140, my lord. If your lordship, my lord, tagged both the matter and here on my lord 30th January, my lord. My lord, learned additional solicitor general will address your lordship, my lord.
Item numbers?
Well, 54 and 140. 140.
I am appearing only in 54, my lord.
Method confinement. This is a 34 petition?
My lord?
This is a section 36 application, my lord.
Today 36, 140 is 34, my lord.
140 of the same, in the same?
Same matter, my lord.
Must be there.
I'm not instructed to appear specifically, my lord, in 140.
Then, my lord,
get the instruction. How is it possible that you will only appear in one? So we'll keep it. When do you want?
My lord, 30th January, my lord.
Why 30th January? Something auspicious?
No, my lord.
He will do puja and then come.
No, my lord. Additional solicitor general, my lord. Otherwise, be some
He will
part.
run our board.
No, not that.
The
My
SG
lord.
will run our board. He will decide.
No, my lord. We are, my lord, praying your lordship, my lord. We are now your lordship will decide everything, my lord. We are praying before lordship, my lord. If your lordship time permit, my lord, then my lord.
Why it's an auspicious day for him?
No, my lord.
Huh?
Otherwise, problem.
Other days are not nice for him.
No. That
or
is
he's so busy.
No, my lord. That is not the case, my
Who's the
lord.
SG?
My lord, Mr. Ashok Chakraborty, my lord.
So, at the request of the counsel for the petitioner, these two matters, let the APCOM so and so be listed together for hearing on 3rd of February. 3rd February.
My lord. Grateful, my lord.
Fine. 55 is my application under section 36, which I want to secure the amount. So the final award is dated 12th of March 2025, which your lordship will find at page 28 of my application. So this award, however, was page 28.
Yes.
This award, however, was not communicated to me as per section 31(5) of the Arbitration Act. I only came to know about this award when the respondent by way of email communicated the same to me. That email your lordship will find at page 33. Page 33 your lordship will find from Rakesh Arora @ Pacific Fire Controls. I am the petitioner before your lordship is Bridge and Roof. Your lordship will find 2 CMD Bridge Roof. Which will see the date of
which page?
Page 33. Till date, your lordship, officially the award has not been communicated to me. I got to know from this email at page 33, which was sent by the respondent. Your lordship will find from Rakesh Arora @ Pacific Fire Controls, which is the respondent before your lordship. 2 CMD Bridge and Roof. Your lordship, Bridge and Roof is the petitioner before your lordship. Your lordship will find the date 6th of May 2025. To such and such. Subject non-payment to Pacific Fire Controls. Final award by MSME Council. Which you will find last paragraph on that page at page 34. Based on these meeting, MSME Council has issued the final award as enclosed, wherein the amount payable with interest calculated till 31st of May 2024 and compounding interest from such and such is yet to be added. In this email, through this email, I get to know that an award has been passed. Based on this, your lordship, on this email communication, I have filed this section 36 before your lordship, in which I am praying for stay of the award by securing the amount. Now, your lordship, I'll just address one point that might come from my learned friend.
There's the award.
Your lordship, the award I had just placed at page 28. Your lordship, this award has been passed by MSME Felicitation Council of Haryana. Page 28, your lordship, at the very top, your lordship will find proceedings before the Haryana Micro and Small Enterprises Facilitation Council in its 352nd meeting.
Have you deposited the money?
No, your lordship, this application is for depositing it. I'm willing to deposit it. The 75% as required under the MSME Act. Your lordship, there might be one objection that my learned friend would take, that since the award has been passed by MSME Haryana, this court's jurisdiction might be challenged. May I just show the jurisdiction clause, the arbitration clause, and one judgment to support this? Your lordship kindly takes up page 70. That is the work order. Page 70 of my application. The relevant two clauses.
No, but then you should go to Chandigarh.
No, your lordship. Subject to correction. Your lordship, I'll rely upon a judgment that even though since the arbitration is a statutory arbitration, it might have taken in Haryana, which becomes the venue, but the seat remains Calcutta. May I just show one judgment after placing these two clauses? Kindly takes page 70 of the work order, 56, jurisdiction. In regard to all disputes or claims arising out of the contract of whatever nature, only the High Court at Kolkata shall alone have the exclusive jurisdiction. So, Lordship, there's an exclusive jurisdiction clause which confers exclusive jurisdiction to the High Court alone. Kindly takes up the arbitration clause thereafter, Your Lordship. Lordship, I'll not place the arbitration clause in its entirety. Kindly comes to page 71, second last paragraph, the penultimate paragraph. The venue of the arbitration.
Where are you reading? Sorry.
Your Lordship, page 71, the penultimate paragraph. This is a part of the arbitration clause. The venue of arbitration shall be such a place as may be fixed by the arbitrator in his sole discretion. So, my argument is the venue might have been Haryana, but the seat of the arbitration remains in Kolkata. And to support this, Your Lordship, I have two judgments, one of the Calcutta High Court and one of Delhi High Court. May I place the Calcutta High Court judgment once? So 2024 SCC Online, Calcutta 10386. Kindly takes up the first 4 paragraphs. The petitioner award debtor prays for stay of operation and setting aside of an arbitral award dated such and such passed by the West Bengal Micro Small Enterprises Facilitation Council. The impugned award was based on a claim of respondent number 1 against the petitioner in a reference made before the Facilitation Council under the provisions of the MSMED Act. The respondent number 1 award holder raises a preliminary objection to the application on the ground that the Calcutta High Court does not have territorial jurisdiction to entertain the application for stay and setting aside of the award. The respondent's argument is premised on the fact that the office of the MSME Council was only the venue for the arbitration and that the dispute resolution clause provides for conciliation and arbitration to be conducted at Bhubaneswar. Learned Counsel places the other clauses of the agreement executed between the parties to urge that the parties agreed that the courts of Odisha shall have exclusive jurisdiction for any disputes, differences, and claims arising out of the agreement. Counsel submits that the venue of the arbitration, that is, office of the MSME Council, cannot be read as the seat of the arbitration. For the purpose of the arbitration proceedings, Counsel submits that in the absence of the arbitration clause, the parties would have to fall back on the exclusive jurisdiction clause, which has not been waived by the parties. Learned Counsel appearing for the petitioner award debtor urges that although the arbitration agreement contemplates the venue to be at Bhubaneswar with exclusive jurisdiction conferred to the courts of Bhubaneswar, respondent number 1 bypassed the arbitration agreement by taking recourse to the provisions of the MSMED Act. Counsel submits that the petitioner invoked Section 18(4) of the MSMED Act and the statutory arbitration under that section decides the seat of the arbitration. Counsel relies on Section 24 of the MSME Act to argue that the arbitration agreement entered into between the parties was superseded by operation of Section 18 of the MSME Act. It is submitted that once the respondent gave a go-by to the arbitration agreement and availed of the statutory dispute resolution mechanism under the MSME Act, the respondent cannot be permitted to go back to the arbitration agreement which the respondent waived by electing the statutory remedy under the MSME Act. The dispute resolution clause is contained in an agreement for design, supply, installation, commissioning of local area network and post-implementation support at such and such, dated such and such, between the petitioner and the respondent for implementing the services to be provided by the respondent to the petitioner. So clauses are referred to. The relevant part of the arbitration clause is set out below. All proceedings shall be conducted, including all documents presented in such proceedings, in the English language. The venue of arbitration shall be at Bhubaneswar only, and jurisdiction for any proceedings arising out of or concerning or connected with such arbitration shall be exclusively of appropriate court at Bhubaneswar under the jurisdiction of the Odisha High Court. For all disputes, appropriate court at Bhubaneswar under the jurisdiction of the Odisha High Court alone shall have exclusive jurisdiction. in all matters arising under this agreement. So here also there was an exclusive jurisdiction clause. In my contract, there's a separate exclusive jurisdiction clause. Now kindly comes to paragraph 8. The question to be answered is therefore, would the arbitration agreement between the parties and the chosen venue be overridden or superseded by the provisions of the MSME Act? If the answer is yes, the Calcutta High Court would have jurisdiction over the application for stay and setting aside of the impugned award passed by the Facilitation Council. If no, the present application would have to be filed before the appropriate court under the jurisdiction of the Odisha High Court. Paragraph 11 thereafter, Your Lordship. Returning to the controversy at hand, Section 18 of the MSME Act transitions from the stage of reference to the council to conciliation between the parties, to arbitration upon the failure of conciliation. Section 18.3 mandates the council to either take up the arbitration itself or refer it to any institution providing alternative dispute resolution services for arbitration. Section 18.3 further provides that the provisions of the Arbitration and Conciliation Act shall apply to the dispute in the same manner as would have been applicable in an arbitration agreement under Section 7.1 of the 1996 Act. Section 18.4 lays down the jurisdictional parameters to the effect that the council shall act as arbitrator in a dispute where the supplier is within its jurisdiction and a buyer located anywhere in India. That's how they draw up the jurisdiction in Haryana. Section 18.5 provides for an outer limit of 90 days from the date of making the reference for a decision by the council. It is evident from the above that Section 18 operates only during pendency of the conciliation or arbitration and ends with the decision of the council. There is no other provision in the MSME Act which points to jurisdiction of any court akin to Section 20 of the 1996 Act. Section 19 of the MSME Act is the only provision which operates post-award, but only in the matter of the pre-deposit of 75% to be put in by the appellant buyer before the appeal or application challenging the award is entertained by a court. Does the statutory arbitration under Section 18.4 of MSME Act, read with Rule 9 of the 2016 rules, decide the seat of the statutory arbitration? This was the question framed. Now, if your Lordship kindly takes up paragraph 15 onwards. The petitioner's argument, however, disturbs the underpinnings of the arbitration as an appropriate dispute resolution mechanism underscored by free and informed choice. The parties' agreement to a designated seat or a venue for the arbitration serves as the base document for all future adjudications in the courts. The arbitration cannot be unseated simply by the statutory arbitration under the provisions of the MSME Act, which in any event is meant to last till the Facilitation Council decides on the reference under Section 18 of the said Act. Further, Section 18.3 of the MSME Act itself provides that the Facilitation Council shall either take up the arbitration or refer the arbitration to any institution or center providing alternate dispute resolution services. This means that the situs of the Facilitation Council alone, even if the petitioner's argument is accepted, cannot become the seat of the arbitration. Moreover, the location of the council can also change in accordance with administrative exigencies. Hence, a peripatetic council surely cannot be equated to the seat of the arbitration. Now, if your Lordship comes directly to the conclusion at paragraph 36, this judgment in so many words clearly holds that the council's jurisdiction is only to the venue and it comes to the end with the arbitration. Kindly takes up paragraph 36. The statutory construction of Section 18 of the MSME Act, read with the case law, definitely points to the parties being directed to their chosen venue, which in the absence of a designated seat would anchor the arbitration to Bhubaneswar. The arbitration conducted by the Facilitation Council in the interregnum cannot confer jurisdiction on the Calcutta High Court in derogation of the venue or seat chosen by the parties. The office of the MSME Facilitation Council was the venue of the arbitration proceedings. The office of the Facilitation Council was not the seat. Jurisdiction cannot be conferred on this court in the challenge to the award passed by the Facilitation Council, since that would be against the preferred venue or seat of the arbitration agreement. This court would therefore be denuded of jurisdiction to hear the present application for setting aside the award passed by the Facilitation Council. The respondent's argument on the maintainability of the present application thus succeeds. So here, Your Lordship, the application was dismissed because the seat of the arbitration was provided in Odisha. Therefore, it was sent back to Bhubaneswar. Here, Your Lordship, in our case, we had exclusively agreed for High Court at Calcutta to be the jurisdiction, the seat of the place. The venue might have been in Haryana, but the seat remains Calcutta, and therefore this section 36 can be maintained. In fact, Your Lordship, just to show one more document from the at page 101, even that section 21 notice was pursuant to clause 57 of the agreement. Kindly takes up page 101. This is the section 21 notice issued by the respondent to the petitioner. Notice under section 21 of the Arbitration and Conciliation Act on behalf of Pacific Fire Controls through one of its directors, such and such. Name of the work is given. If Your Lordship kindly directly comes to page 103, paragraph 7, the relevant portion. That due to non-payment and non-compliance of notice, a dispute has arisen between the parties, and the same is required to be referred to arbitration as per clause 57 of the contract between the parties. My client proposes that the matter be referred to for arbitration to be decided by arbitration, be appointed by chairman cum managing director or director of the Bridge and Roof by an arbitrator to act as sole arbitrator in the matter and decide the dispute in accordance with law. So even they, under the section 21 notice, invoke the clause in the agreement contained between the parties. They might have later gone to the MSME council, but that does not denude this court of the jurisdiction. So one more judgment on this same issue by Delhi High Court, if Your Lordship permits me to. Not required, Lordship. Very well. So that Delhi High Court is the division bench, just to satisfy Your Lordship on the authority of the judgment.
My Lord, may I? I am for the respondent.
Yes.
My Lord, this award has been passed by the MSME Council, Haryana. After passing the award, the conduct of the petitioner was, you can see, my Lord, from page number 123.
You're not challenging the jurisdiction, right?
No, they have filed an application under under Order 9, Rule 13 before the arbitrator on 8th April 2025. And they are saying they are no knowledge about the passing the award. When respondent are appearing on the day of via video conferencing when award was passed. Award has been passed on 12th March 2025. The limitation period is to file the section 34 application in 3 months and 30 days. That has been elapsed. They have raised a new point that I have sent an email. From there they have come to knowledge. But arbitrator record, if arbitrator record would be placed that they have already received the award on the day sometime in the March. Thereafter, after passing this award, they have preferred an application under Order 9 Rule 13 before the arbitrator. Subsequently, at page number 147, they have filed an application before the arbitrator under section 16. They have filed, after passing the award, they have filed 2 applications before the arbitrator. One is at page volume 2, page 123, and second application is at page 147. That is section 16 application before the arbitrator after passing the award. And they are saying they have no knowledge about the award. They have only came to know about the award on when I have sent the email. They have written any letter to the arbitrator that award has been passed or not. You have not communicated. There is no averment to that effect. They have filed the application at a belated stage. That can't be permitted. Moreover, the my lord question of stay when prima facie case has been made out by the petitioner. Prima facie case is only 7 ground to challenge an arbitral award. 5 ground is laid down in section 34 2A, Roman 1 to 5. And 2, is if there is section 16, if you challenge the jurisdiction and our arbitrator council has proceeded with the award and passed the award under section 16 subsection 5, you can challenge the award on the jurisdiction value. And third is section 13 subsection 5. If any procedure, only 7 grounds they have, they cannot demonstrate is the 7 ground to challenge the award. If they can't challenge the award, they cannot make out a case under all the 7 grounds. Then how their application under section 36 be entertained or 34 be entertained? If 34 goes, what remains? Section 34 application is
36.
Lordship, I have filed a 34 as well, which is
that is listed as monthly serial number 141.
141, Your Lordship.
So first you have to consider the 34.
Yes, my lord.
Your Lordship, this is
36 2 only comes after MSME award, after the payment 19 has been made.
Lordship, the other judgment stands.
Justice Bhattacharya's order is, must have seen that.
Yes, Your Lordship, the other order says that until and unless
still bond, baby. That's the word which
yes, Your Lordship. So until and unless I secure it, I cannot, the 34 is not born.
Not at all. First in 34, you have to make the payment. Then only
Lordship, I am ready to
36
make the
2
payment.
can actually be heard.
Lordship, I'm ready to make the payment either under 34 or under
See
36.
that whether you can
Lordship,
make the
kindly
payment or
take
not, whether it is barred by
Very well, Your Lordship.
limitation or not barred by limitation.
Very well, Lordship. Then kindly takes up the 34. I'm ready with that as well. If Your Lordship so wishes.
Take the 34. We'll list it next week for hearing.
Lordship, only one predicament that I'm facing is that they have filed an execution in Haryana.
Whatever it is, we'll have it.
It's listed
next
on
week.
13. Lordship, they've sought for accommodation previous times as well. So on personal grounds, I did not oppose. But Your Lordship, kindly,
Nothing can be done.
I'm ready with
which
the
is that
34
item?
as well, subject to what?
141.
141.
AP number?
AP number, Your Lordship.
721.
इसमें लिखो, let AP number so and so be listed along with the present AP for hearing on.
721.
Give a date. Come on Friday.
Very well, Lordship.
Friday. Come on Friday. We'll hear you on Friday.
Grateful. Lordship, the affidavit of service may be kept on with.
Affidavit of service taken on record.
Grateful, Lordship.
Non-commercial.
Active service as notice of motion. Well, I beg to appear. Notice of motion and affidavit of service. Well, here I have challenged my appointment of my lord arbitrator unilaterally despite objection, my lord. The arbitrator already, my lord, issued notice.
Who's for the respondent?
I have served, my lord. This is Tata
Tata
Capital. Tata Capital Limited.
Generally they're here. Just inform them so that we can pass a, I'm sure they will consent to.
Yes, my lord.
Then we can have a fresh appointment and finish it off rather than.
Then I shall serve another notice.
Just inform them, whoever the council is, just serve. You come back tomorrow, not today.
Tomorrow, my lord.
Oh, tomorrow is Thursday. Come back on Tuesday then. Not this week. Come back on Tuesday.
Because it will take time. Well, I shall serve notice, then they will
Just
come.
inform the council. These are regular council.
Who is appearing in this matter? I do not know. That is the problem.
Regular councils of Tata, they have so many matters every day.
Yes.
These are the
Yes,
regular.
I shall try. my lord.
Just try it so that we can finish it off.
Yes, my
That's
lord.
the whole idea.
কবে থাকবে?
I'm sure they'll consent to the change of the appointment of.
Yes, a new arbitrator
new
that can be,
arbitrator
my
can
lord, subs of the matter.
Exactly.
We miss your lordship in appellate side now.
That's what we want to do, finish it off.
Yes.
My lord, item number 2, I am appearing for the petitioner, my lord.
Lordship, I am appearing
My
for
lord,
the.
this is an application for extension of the mandate of the learned arbitrator, my lord.
I'm not objecting to that.
My lord, the mandate was expired on.
Give me the date, Ms. Bawal.
Yes, my lord, the mandate was expired on 23rd.
Appointment
December
date, appointment
2021.
date.
Appointment date. My lord, arbitrator was appointed, my lord. The by an order dated 21st November 2029.
1st November
21st November
21st.
2019.
20.
The arbitrator was appointed.
All right.
And my lord, the first.
Pleadings are completed.
Yes, pleadings are concluded, my lord. It is, my lord, at argument stage. The argument on.
Pleadings are completed on.
My lord.
Do you have the date?
Yes, my lord, the pleadings are completed, my lord. My lord, my lord, pleadings were completed on, my lord, October 2021, my lord. Pleadings were completed.
So there were two arbitrators. One is Shailendra.
Yes, earlier occasion, my lord, previously, my lord, in the year 2017, one arbitrator was appointed, but that arbitration proceedings was terminated, my lord. Thereafter, we made an application for fresh appointment by an order dated 21st November 2019. The present arbitrator was appointed, my lord. Thereafter, my lord, pleadings were completed in the month of October 2021, and issues were framed, my lord, on 4th March 2022. And my lord, thereafter, examination of CW1 was commenced. In the meantime, my lord, the mandate was extended for a period of 6 months by consent of the parties on 27th October 2021. My lord, thereafter, my lord, the mandate was extended first time on 30th August 2023, my lord. I have annexed the order at page 32. Thereafter, my lord, on 2 occasions, the mandate was extended for a period of 1 year, my lord. Last, it was extended on 23rd December 2024 at page 42, my lord. Page 42. 1 year from the date of communication of this order, and my lord, it expired on 23rd December 2025, and I affirmed this application on 19th December 2025. My lord, I am praying for 1 year extension.
1
my
year
lord,
can't be
because my lord, there is my lord, there are voluminous documents, my lord.
Still you
My
have
lord,
got
the
almost.
argument on behalf of the respondent is continuing. Thereafter, my lord, I will make our reply. Thereafter, my lord.
1 year not possible. You have already sought 2 extensions. 2 extensions have been granted to you. How much time will the arbitrator take? Tell him to expedite it. Yes.
Lordship, I don't have any objection to the extension.
How much time do you think it will be reasonable?
Lordship, this will take some time.
Why?
At least 8 months, if not 1 year, 8 months, Lordship.
The present application has been filed under Section 29A of the Arbitration, 29(1) of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal for conducting the proceedings and publication of the award. 29A of the Arbitration and Conciliation Act. This is the learned counsel for the, what is the date? This court initially had appointed. This court wide order dated
21st November 2021.
No, the first one is
11 December 2017.
11th December 2017, appointed Justice Shailendra Prasad Thakur as the sole arbitrator to adjudicate the dispute between the parties. Full stop. However, wide order dated 7/12/2018, his mandate was terminated. Full stop. The petitioner approached this court for the appointment of a substituted arbitrator. Full stop. Hence, this court, by order dated 21/11/2019, appointed Justice Tapan Kumar Das as the sole arbitrator. Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended by 6 months. Full stop. Thereafter, this court, by order dated 31/8/2023, 29/12/2023, and 23/12/2024, extended the mandate of the tribunal by 4 months, 1 year, and 1 year respectively. Full stop. The tribunal, it is stated by the learned counsel for the petitioner, Ms. Bhowal, that the tribunal has held 71 sittings and that the matter is at the stage of final arguments. Full stop. Learned counsel for the respondent states that she has no objection to the extension of the mandate of the arbitral tribunal for conclusion of the arbitral proceedings and publication of the award. Full stop. This court notes that already 2 years, 4 months extension has been granted to the learned arbitrator to conclude the proceedings. The learned arbitrator has conducted more than 74 sittings and recorded the evidence extensively. Full stop. The matter is at the stage of final arguments. Full stop. Upon consideration of the submission and the materials placed on record, comma, this court is satisfied that there has been no undue or unwarranted delay on part of the sole arbitrator in conducting the arbitral proceedings. Full stop. Accordingly, it is further noted that the matter is at an advanced stage, and in the interest of justice, this court extends the mandate of the arbitral tribunal further for a period of 8 months from today. Full stop. The learned sole arbitrator is requested to make all reasonable endeavors to complete the proceedings and publish the award within the extended time period. With the aforesaid observation, comma, the present petition stands disposed of.
My lord, 8 months, my lord, from the date of the
From
order.
today. From today. Yes.
My lord, Mr. Mishra is busy in another court. My lord, short pause.
Busy?
My lord, in this matter, if your lordship recalls, my lord, Mr. Mishra had requested for 3 days time to file an application before your lordship to direct the department to transfer the section 36 from the ordinary side to the commercial division.
All right, not today.
Grateful.
Lord, I appear for the petitioner, my lord. I am led by Mr. Tariq Banerjee. Is appearing.
Lordship, I appear for the petitioner. I am very sorry, Lordship, I am appearing virtually. Lordship, I should be very candid before I open my submission. This was wrongly filed before the non-commercial division. This should have been filed before the commercial division. Your Lordship kindly allows transfer of this petition to the commercial division.
This application is not at all maintainable. No interim relief may be granted to this. Suit has been filed in connection with the suit. Injunction or status quo order is there. The other side appeared. My lord, that has not been stayed. My lord, for the my lord, a contrary relief has been prayed for in by filing this application, my lord. And my lord, he is asking in virtually asking for the final relief in the interim section 9 petition, which cannot be
Lordship,
done.
when your Lordship takes it up, I will move it. Suit has been filed by the respondent for protection of his rights.
Yes,
I have filed the section and I am governed by the arbitration clause for protection of my right. So when your Lordship takes it up, I will move. The fact is that your Lordship, the respondent is staying in my property without paying a single penny. He is a tenant using my godown for commercial purpose without paying a single penny from March 2024. And my godown is under precarious condition. The godown has developed cracks. Is it a very damaged, bad condition, Your Lordship? Also,
At least file it in the right.
yes, Your Lordship. That's why I sought for a transfer, Your Lordship. At the very opening stage, I sought for a transfer.
What transfer? Make the withdraw this petition, file appropriate proceedings.
Lordship, Your Lordship has earlier allowed a petition to be transferred and filed for the commercial division. I was only humbly praying if Your Lordship kindly grants that prayer.
Not limitation here. Withdraw the petition, file it in the appropriate with the appropriate proceedings.
Then Your Lordship will grant us that liberty to file fresh.
Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file it. With liberty to file appropriate proceedings in accordance with law.
Great.
Dismissed as withdrawn.
Great.
Grateful, madam.
May it please your Lordship, Milord, I am appearing on behalf of the petitioner to this application, which is, Milord, a challenge for setting aside of an award dated December 21, 2018. Milord, there is an affidavit in opposition filed to this application. There is also a supplementary affidavit filed to disclose, Milord, certain documents of the arbitral record. Milord, in a very, Milord, briefly, if I may indicate, I know there is only 9 minutes left or maybe 7 minutes for myself. I will have to, Milord, request your Lordship so that I get an opportunity on Friday, because I am ready and I intend to, Milord, complete the hearing of this matter.
Award is of which year?
Milord, it is of 21st December 2018. And we have received an email from the other side that we are not proceeding with the matter. So I burned the midnight oil and I do not intend to forget.
We won't waste it.
Milord, may I just indicate, Milord, just the brief facts? Milord, the petitioner before your Lordship is West Bengal Housing. And Milord, the respondent, who was the claimant before the arbitral tribunal, is one Abhishek Construction, a partnership concern. Now, Milord, the partnership concern, the contractor was given a work which had the total value of 1 crore 19 lakh for some civil constructions. The original time period was 2 months. And the work could not be completed within that 2 months' time. It got completed within 9 months, 26 days. Because of that, an additional 7 months, 26 days, the claimant contractor had a claim in the nature of damages. That is price escalation. They said that in those 7 months, cost of labor, material.
What were you constructing?
Milord, it was paver blocks. I was not constructing, Milord. The contractor was constructing paver blocks and etc., Milord, on a piece of land, where other construction and contractors were also working together. So, Milord, on this anvil, because of the allegation of delay which the contractor had against us, they had a claim of loss and damage, which was, Milord, to the account of rupees 92 lakh. And there was also, Milord, a claim for unpaid bill.
Yes.
We also had a counter claim, but, Milord, I do not intend to proceed with that before your Lordship, because I find from the contract it was not maintainable. Now, the Honorable Arbitrator, Milord, who was, Milord, appointed at our instance, because the contract said so.
Yes.
He proceeded to pass an award by holding that both the respondent, that is the West Bengal Housing,
yes,
that is respondent before the arbitrator, and the contractor are liable for delay. Both of them are liable for delay. Lordship will appreciate that West Bengal Housing has not terminated the contract. West Bengal Housing has paid the entire contractual amount. The contractual amount was reduced subsequently because of the change of work. And 88 lakh was paid to Abhishek Construction, which they have received in full. But the arbitrator holds that there is delay on the part of both the parties. But thereafter, the arbitrator apportions the delay. He says that West Bengal Housing is to be blamed for 4 months and Abhishek Construction is to be blamed for 3 months, 26 days. Unfortunately, Milord, I have not been able to even strenuously cull out a reasoning behind this. But be that as it may, the arbitrator in simple sense finds both the parties to be the cause of delay. And thereafter, my lord, he goes ahead to evaluate the loss and damage suffered on grounds which appears to him as reasonable. He does not call for evidence. There is no material proof before the arbitrator from where actual cause of damage can be ascertained. This is, my lord, the sum and substance of my challenge. My challenge basically, my lord, is on three folds. It is patently illegal because it does not satisfy the provision of section 73 of the Indian Contract Act. Actual loss has to be backed up by actual proof of damages. And secondly, my lord, there is lack of reasoning. And lastly, my lord, the arbitrator cannot supplant reasons by thinking that it is justifiable and in process completely ignore well-settled provisions of law. Lord, may I invite your lordships to volume 2, just one portion of the award to show what are the claims which have been allowed. My lord, the award starts after page 299 because it is not paginated, my lord. My lord will kindly come to page 9.
Page 9 of?
Internal page 9 of the award.
Award starts from 299.
299, after 299. It is not paginated, my lord.
Yes.
So, my lord, this is the claim which I am, my lord, aggrieved with. The first claim, this is just the only thing which I would, my lord, show your lordship. Page 9, I hope your lordship has the claim. It's a chart which the learned arbitrator has taken from the statement of claim. So, my lord, the first is work executed but not paid, 3,70,000. The learned arbitrator has not allowed this against us because he holds that there is no evidence to this effect. So, the learned arbitrator, despite being an engineer, was well aware of the importance of laying evidence. The second, my lord, is compensation on account of prolongation of job attributable to the employer towards on-site and off-site. So, according to the respondent Abhishek Construction, the contractor, they had some additional expenses for that 7 months, 26 days additional time. Off-site was 1,50,000 and on-site was 9,60,000. This was their claim. The learned arbitrator, he says that no, you will not get it for the entire 7 months, 26 days. 4 months is the fault of West Bengal Housing. So he divides it by 4 and awards it. He does not call for evidence. This is simpliciter in the nature of compensation for loss and damage alleged to have been suffered. The first thing is to call upon a person and ask him to show whether you have actually suffered loss, which means whether you have employed anybody on-site or off-site, and most importantly, whether you have paid money to that person. And then by collating those documents, the arbitrator would have come to a finding that this is the actual cost and this is the award. This, my lord, has been the line of reasoning of the arbitrator. According to him, he has paid lump sum amounts thinking that it is reasonable, which, my lord, in my most humble submission, is dehors section 73 and beyond the contractual scope and hence patently illegal.
We'll hear it. Heard, Mr. So-and-so. Keep it.
Well, Rohit Banerjee.
Mr. Rohit Banerjee.
Yes.
Mr. Rohit Banerjee. Keep it for further hearing on. When do you want both the parties?
My lord, can it be Friday anytime which you
keep on Friday?
Yes, yes, but I'm sorry, my lord.
Yes. If you want effective hearing, give some other date. When do you want?
My lord, anytime, any day which is convenient to your lordship. Tuesday, my lord, if that is
Tuesday. Non-commercial 20th Tuesday. Huh? Non-commercial Tuesday 20th. 2-0.
Yes.